mystery to much of the public. Our mission today is to help you unravel that mystery so that the public can better benefit from your efforts to explain what we do and how the judiciary affects the lives of people in Michigan. For example, many people probably wonder just what court handles which kinds of cases. Circuit court, district court, probate court. What's the difference between what the Court of Appeals does and what we do up here at the Supreme Court? Most members of the public have no idea what the State Court Administrative Office does, or even that it exists, but their work is critical to the success of the court system. And many people may not know about our innovative drug, sobriety, and mental health and veterans courts, which are transforming so many lives. These are just a few examples. Our aim today is to fill in any gaps so that you are fully informed when you write about the courts. The court has been working hard to find new ways to communicate with you and with the public. Social media is critically important to that effort. We've been using social media sites such as Facebook and Twitter to post real-time information about the court's opinions, our public events like our statewide adoption day, and various facets of court administration. So if you don't already do so, we encourage you to like us on Facebook and follow us on Twitter so that you can stay abreast of what we're up to up here. Michigan's judiciary is committed to being a national model in terms of accountability, efficiency, and service to the public. We are very proud of the steps we have taken thus far to right-size our courts, streamlining our processes, reducing the number of judges, sharing resources, implementing new technology, adopting best practices, and measuring performance. We're constantly collecting data, analyzing that data, and taking action to improve outcomes so that all of the people of Michigan can be served and so that we can be the best possible stewards of the public resources entrusted to us. Courts throughout the state have been transformed to focus on court users as if they were customers, and you can see the results of that. Some of those results are in the annual reports that have been distributed, and I urge you to read those and learn more about what we have been doing on those regard. I hope you will enjoy today's sessions and that you will come away with a better understanding of Michigan's judicial system and how we are striving to serve the people of our state. Thank you very much. Oh, am I supposed to say?
Yes. No, we're all, thank you very much, Justice Larsen. Okay. That was perfect. Great, thank you. Now we'll start into our first educational session, and it's the Which Court District Circuit Probate. We're going to take 15 minutes each and learn about each of those courts. And our first speaker in this segment of our program is the Honorable Louise Alderson. She's a judge in the 54A District Court right here in Ingham County. Judge Alderson.
Thank you. I appreciate the opportunity to come and speak with you today about the District Court. I hope to tell you a little bit about what we do in the District Court on a daily basis and then give you some opportunity to understand how you may be able to access some information about the court. I think we are one of the busiest courts with regard to our criminal dockets. We are the court of entry for all criminal matters in the state. But I'm going to diverge a little bit and start with our civil docket so that you can understand what other types of cases are going on in the district court and some other things that you might want to follow in the district court. I'd say probably about 70% of what we do in the district court is criminal in nature and about 30% would be civil. There's three areas or general areas with regard to our civil docket in the district court. And first of all, that would be our general civil docket. These are matters where individuals are coming to court to ask for damages less than $25,000. So you've got a lot of collection matters, people suing in the district court for non-payment, small contract disputes, and we've also had a number of increasing small insurance matters, first-party claims. The second biggest area in our civil division would be our landlord-tenant matter. And for the most part, these are landlords that are suing for unpaid rents or termination of tenancies for individuals who are breaching their lease for some reason. We can also deal with land contract matters in the district court and holdover tenants after sheriff sales. Also, tenants can also countersue. It's in that landlord-tenant matter if they have issues with regard to habitability, and these are some of the kind of issues that the press have followed recently. There's been a lot of issues with regard to bed bugs and those kind of things that are happening in rental housing. In Lansing in particular, about 40% of our housing stock is rental units. So each day, there's the half-day schedule for each judge, and we run from 20 to 40 cases in a half day with regard to either unpaid rents or termination of tenancies. But for the press, there's been some coverage about habitability issues with regard to the livability of these rental units. We've also had some issues about mobile homes, which would also be handled in the district court as well. The third area is small claims, and if you think Judge Judy, that would be the actual type of claims that we have. It used to be what really a small claims matter, $1,500 up to $3,000, but most recently the legislature has increased that jurisdiction in the small claims up to, currently it's $5,500, and it'll be increasing up to $7,000 by 2024. There's no attorneys in a small claims case. The rules of evidence don't apply, and so a judge or a magistrate will be hearing a civil case and let each side tell their story and have an opportunity to state their case, and the judge or magistrate will make their decision based on the case, the information, and the law that applies in that case. Because the jurisdiction has increased to the 7,000 level, a lot of those cases that used to be filed in the General Civil Division have been moved to small claims because they don't have to, folks won't have to hire attorneys. And it's kind of an interesting area to, for the press to watch if you are interested in interesting cases. The amount of cases that we're seeing in our small claims is really increasing across the state. I've been on the bench for about 15 years now, and I can tell you about the only general civil cases or civil cases that have been of interest to the press are the ones that I just talked about. Either there's someone of notoriety who's being sued for something, an elected official, or some other of interest, such as the habitability concerns, that the stories on bed bugs and the nature of the housing itself. I think that the press is most interested in our criminal docket, as I indicated before, that the district court is the court of entry for all criminal matters. The two biggest categories of criminal offenses are misdemeanor and felony. A misdemeanor is a crime that is punishable by up to 1 year in jail, and a felony is a year and a day up to life in prison. It's the only really definitional piece between a misdemeanor and a felony. And the district court has complete jurisdiction over misdemeanors, everything from the signing of the complaint and warrant all through sentencing and probation. For the felony cases, the district court only handles the original swear-to, or the signing of the complaint and warrant, through the preliminary examination. And I'm going to start with misdemeanor cases. I want to also note that the district court does take care of everything from parking tickets, civil infraction tickets, which are speeding tickets, and then misdemeanor, any kind of misdemeanor cases as well. So a misdemeanor case can begin with a ticket that's being authorized by a police officer, or can be initiated by a prosecuting official, which could be a city attorney, a prosecutor, or the attorney general, on a complaint and warrant. A magistrate or a judge can sign those warrants, and that means that the person comes in front of a judge and explains what the probable cause is to issue that misdemeanor complaint. Misdemeanor complaints do not need to be on the record, so you won't have the same swear-to that you would have in the felony case. Once that complaint has been issued and the individual has been arrested on the warrant, the court will set a pretrial date, and after that there will be a bench trial or a jury trial. All of that information is open to the public and to the press, and all court proceedings are open to the press and the public. However, following sentencing, there may be certain cases that have been delegated as non-public. So if you came to the counter and asked for certain cases, if they have been delegated as a non-public case, then the court staff would have been advised to let you know that there's no information available about that case, and those are the only kind of cases that would not be open to the press or to the public. Felonies themselves run on a completely different track. Felonies are, as I indicated, anything where the possible penalty is more than a year in jail, and you would want to, once the complaining party, which is usually a police officer, comes to the judge and swears to the complaint. They're giving their belief, their probable cause to believe that this crime occurred and that the individual committed that crime. That has to be an open record, an open document, and that's been something that the press has come to get as a part of their gathering of information. However, that swear to can be done at any time. It does need to be on the record. Press usually aren't aware of when those are being done, but you can be in the courtroom when the officers are there doing the swear to, or you can request a transcript of that swear to from the court recorder. Obviously, there'll be payment for that, and if you need it on your kind of schedule, it's probably going to get an expedited fee for that, but the staffs are willing to do that for the press. Once the complaint and warrant is authorized and an individual has been arrested on a complaint, then it's the judge's duty to arraign them on the charge. The arraignment is a court proceeding on the record where the individual is advised of the crime that they've been committed and the possible penalty. They're advised of what their rights are in the situation, and the court sets a bond. That's pretty much all that happens at an original appearance on the arraignment on the complaint. For a felony case, then it's set for the statute was just changed recently for a probable cause conference, and that has to be done within 7 to 14 days following their arraignment. So it's a pretty fast-tracked requirement for the court to schedule those we call them pre-exam conferences, but the statute calls them probable cause conferences. Around the state, you'll have different practices on how the district courts handle that, because the statute allows those probable cause conferences. They don't have to be even at the court. They can be done between the prosecuting official and the defense attorney. We try to get them to come to court so that everyone can meet with the judge to find out if there's any discovery issues that are going to be needed. If people are going to need extra time than the original 21 days that are afforded to them. And we try to set them on the docket and let everyone know when the next date is for the appearance. It's been an issue with regard to the press of knowing when all the parties are going to be there, when to come to court, so that you can take care of that hearing. At the probable cause conference, many things can happen. We can just schedule it on for the next event, which would be the preliminary examination. The parties can choose to waive the preliminary examination, which means there will not be any testimony taken, and the parties just make their decision to go to the circuit court where there'll be a trial or plea taking. The parties can enter into a plea bargain right at the district court, and if it's a misdemeanor plea, then the district court will take total jurisdiction over that case. District court judges also have the authority to take a felony plea in district court. They'll actually take the plea, but the sentencing will be done in the circuit court by a circuit judge. And the final thing is, at the preliminary exam, the exam actually can be held. The judge's responsibility is to make a determination of whether the defendant committed that crime and whether a crime was committed and the defendant committed that crime. So you're looking not only about the elements of the crime itself, but whether there's identification of this particular individual. Identity comes in when someone's obviously wearing a mask during an armed robbery or something like that, or if there hasn't been a good definition of who the actual accused is. The exam, once the exam is held, then the case is bound over to the circuit court, and it's up to the circuit court then to take over the case from that point in time. So that's pretty much, I'm trying to get in a nutshell what we do with regard to both civil and criminal matters. Judges do have jurisdiction over their courtrooms. Unless there's a specific statute, these courtrooms need to be open to the public. So everyone is welcome to be in the courtroom. The one major one where the court can close a courtroom is if there's a child testifying with regard to criminal sexual conduct, and the court has the authority to close the courtroom for that purpose. But the judge also has authority over what kind of filming equipment or what kind of other, you can be in to just take notes or anything, but if you're taking film equipment or audio equipment in, then you have to file a document with the court to let them know that you're going to be there doing that. It's best to talk to your court staff and find out what that particular judge requires for extra media in the courtroom. Some of the judges have people set up in the jury box or in the back of the courtroom so that it at least disrupts the rest of the activity in the courtroom. I would say to make friends with the court staff. They're the ones that know what's going on, and they're the ones that can give you the most information. When you're coming and going in the courtroom, remember that the case that you're following is going to be one of many that the court has on that day. Your equipment seems to be rather noisy. So if you can set up and take down, put up and take down with a minimum of that noise, it will help on other matters. What I need to leave you with is the fact that there are 106 district courts in the state of Michigan, and there's about over 250 district court judges. And while the procedures that I've given you are required over all of them, there are local practice. And so it's important for you to get out there and meet your local judges and meet the local court staff to know how they're handled individually. I want to encourage you to visit your local court, meet your judges, ask questions, sit down with them, so that when it comes to that controversial case, you've already had that relationship and you're ready to go. The courts, district courts, are getting much more online with a lot of their information. I know at the 54A District Court in Lansing, we have our entire case management system is online, and it's accessible through our website. You can also get the court schedule through the website, and I'd encourage you to use that as well. We also have things like online ticket payments and other ways that you can access the court services through online practices. And I'm getting next to my end zone, so I just want to leave you with the opportunity to come and speak with us, and I appreciate the opportunity to let you know what we do in the district court. Thank you.
Great. Thank you very much, Judge Alderson. And now our next speaker this morning at the Michigan Supreme Court Law School for Journalists is the Honorable Michelle Rick. She's a judge in the 29th Circuit Court in Clinton County. Judge Rick.
Thank you. Good morning. As indicated, I am a circuit judge for the 29th Circuit Court. The 29th Circuit is comprised of Clinton and Gratiot counties. And for those of you not familiar with where those counties sit in our state, if you think in terms of college campuses, we are north of my undergraduate alma mater, Michigan State University, and south of Central Michigan University. St. John's and Ithaca are my county seats. Alma College is located in the 29th Circuit Court. I'd first like to start by sharing some very basic facts with you about circuit courts. Circuit judges are elected at nonpartisan elections in the circuit in which they reside. Circuit judges serve 6-year terms. In Michigan, there are 57 circuits across the state's 5 regions. The 29th Circuit is located within Region 3, which essentially is the middle of the mitten, if you can envision that of the Lower Peninsula. Region 3 is made up of a sum total of 27 counties with 16 circuit courts who are served by 28 circuit court judges. As of June 27th of 2015, there are 213 circuit court judges. That number, like those of the probate and district court judges, is somewhat fluid. That is because all state courts, in partnership with the State Court Administrative Office, participate in a biennial review of judicial workloads. From that review, a report entitled the Judicial Resources Recommendation, or JRR, is produced. And because of recommendations in the 2011 and 2013 JRR, upon recommendation of the Chief Justice of the State Supreme Court, the legislature approved the elimination of 45 judgeships, inclusive of trial courts and Court of Appeals. The 2015 JRR, which came out in June of 2015, or thereabouts, has recommended reducing 9 trial court judgeships and adding 3 for a net of a loss of 6 judgeships statewide. Those reductions are implemented when a judge either leaves office or passes away. By working collaboratively with the Supreme Court, the State Court Administrative Office, and the legislature, Trial courts are achieving efficiencies, and taxpayers are saving hundreds of millions of dollars by right-sizing the judiciary. I'd like to next talk with you about the kinds of cases that are brought in the circuit court. Circuit courts are courts of general jurisdiction. They have very broad powers. By statute, the circuit court is authorized to hear all civil cases where the case in controversy or amount in controversy is $25,000 or more, as well as those cases where injunctive relief is requested. Additionally, the circuit court has jurisdiction over adult felony matters. That is to say, as you have already heard, that for those crimes where a person can receive a prison sentence. The circuit court has jurisdiction over family and domestic relations cases, such as divorces, paternity cases, juvenile proceedings, adoptions, and personal protection order requests. The circuit court also hears appeals from lower state trial courts, as well as from State of Michigan administrative agencies. Each circuit court in Michigan has adopted a family court plan, which defines the family and domestic cases that the circuit judges assigned to the family division will hear. In the 29th Circuit Court, I share family cases with each of the two probates in my respective two counties. These are the kinds of cases that I hear assigned to the family division within the 29th Circuit Court: divorces, paternity, custody, parenting time, child support, and personal protection orders. Under my court's family court plan, I do not hear adoption, child protection, delinquency, or emancipation cases. Those instead are exclusively managed by the probate judge in each of the two counties that I serve. I share the felony and civil docket with my benchmate, Judge Randy Tavonen. When a new civil case is filed, the circuit court clerk will assign the case either to myself or Judge Tavonen. Felony matters are assigned to us by the district court only after a probable cause determination has been made in that court. As I mentioned, I am one of two elected circuit court judges, although we will receive a reduction of one circuit court judgeship by attrition as a result of the JRR I talked about earlier. In preparation for that transition, all of the judges within the 29th Circuit Court, including our district and probate judges, have collaborated to ensure that quality service, which our customers are accustomed to and expect, will continue when our circuit is reduced by attrition in the upcoming years. To accomplish this, we have a concurrent jurisdiction plan and cross-assignment orders in place. Those items permit any judge within the 29th Circuit to hear any case filed in the probate, district, or circuit courts. For our immediate purposes, these plans have enabled us to back each other up without need of incurring the cost of a visiting judge, as well as giving us the ability to reach out and to create specialty and treatment courts, which are designed to address the special needs that some of our criminal litigants have. In the 29th Circuit Court, we have a mental health treatment court, a sobriety court, and a Swift Insure Sanctions probation program. Our district judges oversee the mental health court and sobriety court, and litigants in those courts may include misdemeanants or felons. As for me, I operate the Swift Insure Sanctions probation program. That is a program designed for high-risk felony offenders. The Swift Insure Sanctions program, which I call Swift Insure for short, is patterned after a highly successful high-risk felony court operated by a judge named Steve Alm in Hawaii. His court is called Hope Court, which stands for Hawaii Opportunity for Probation with Enforcement. The foundation of Hope and Swift Insure is commitment to the tenet that probationers are most likely to be successful on probation when orders of probation are uniformly and consistently enforced. A goal of Swift and Sure is to help these offenders return safely to our communities while giving them tools so they are less likely to reoffend. It is no wonder that if you hear Judge Alm talk about it, that probationers might fail at probation historically, causing them at times to end up in prison because there have been inconsistencies in their management over the course of probation. In other words, there have been times where these individuals have been given passes and other times where orders have been enforced. There are no passes in Swift and Sure. We use a graduated sanctions grid which is swiftly and surely imposed for violations for items like failing to make a scheduled appointment with one's probation officer or someone at the Department of Community Health, to having a drug test or an alcohol test come back positive. We are in the 29th Circuit Court completing our second year of Swift and Sure, and we have had several graduations and they have been quite heartwarming. I would particularly like to extend gratitude to Justice Larsen, who has reached out to us from the Supreme Court to provide our graduates with congratulatory letters for graduating from Swift and Sure. Those letters have a very special meaning to our litigants, who at one time were faced with possible lengthy prison sentences. These are my remarks on the Circuit Court, given my time allotment. I want to extend to those of you either in person or participating over the web that I serve as the co-chair for the Outreach and Planning Committee for the Michigan Judges Association. And at any time, I would invite any member of the media to contact me should you have questions about circuit court operations or processes. The judicial canons do not permit judges to comment on pending cases. And additionally, because each case is unique and has facts known only to those who participate in the adjudication, I would not be able to comment upon decisions made by any of my peers. However, if you do have a question about operations, process, how do the felony sentencing guidelines work, or any other matters, I would be delighted to engage in any discussion with you. Thank you for listening and learning about the Circuit Court.
Thank you very much, Judge Beck. I'd like to just let folks in the courtroom know that we do have several dozen journalists who are watching online. So this exercise is working out quite well so far. And I'd like to introduce our next speaker. And he's representing the Eaton County Probate Court. This is the Honorable Tom Byerley.
Okay.
Judge Byerley.
Thank you very much and welcome to all of you. It's my pleasure to serve as the probate judge in Eaton County, which is just west of Ingham County where we're standing now. It's the probate court, which I call the third leg of the three-legged stools of the trial courts. There are three trial courts, as we mentioned, and I represent the third of those. Together, we constitute all of the trial courts in the state and handle the matters where people come in, testify, and have trials, and get the day-to-day things done that people need to do when they go to courts, and then they go to the appellate courts after us. But when most people think of the label of probate court, they think of estates, wills, and trusts. Estates are, of course, when people die and they have property that has to be distributed after their death. That's either done sometimes with a will, or sometimes it's done without a will. And then the statutes of the state of Michigan then write a will for somebody who hasn't written a will. And so it's up to the probate courts to determine then what is the best use of the property or where should it go under those laws. We also handle what's called trust, which is when people put their assets into what we call a living trust in many cases. It's analogous to when a person incorporates a business, they they make a corporation. That corporation is a legal entity, and then the corporation owns the assets of the business. The same is true with the trust. A person puts their assets into the trust. The trust is then a legal entity of its own, and then after the person dies, the trust still owns the assets, and then the trust decides where they go. It was a tool that has been devised over the years to avoid what they call the typical estate planning, where you go through the probate court and you have your wills contested or not contested. Trusts, by the way, right now are getting less popular. One of the main reasons trusts were used in recent years for estate planning was it was a way to guard assets from the reaches of the federal government for Medicaid reimbursement. Those rules are now changing. The government's deciding that they want to have access to some of those funds in the trust. Some of the laws have changed, and so some of the advantages of a trust are not as strong as they used to be. So many estate planning attorneys are changing estate planning to move away from living trusts, and that could take me hours to explain all that, so I won't. The feeling, unfortunately, is that probate courts are wills, trusts, and estates. That's probably about 6% of the work that we do in probate court. So even though that's what people think of, it's a very small portion of what we actually do. What we do in addition to that, the first thing would be guardianships. And a guardianship is a situation where a person needs someone else to help make important decisions for them, such as medical treatment, where they live, those types of issues. And there's different types of guardianships, of course. For adults, again, the typical thing that we see most of the time are people in their advancing years who are having signs of dementia, and they're not able to, again, make their appropriate decisions for themselves. So somebody will file a petition to act as their guardian to help them make decisions. Sometimes it's a family member, sometimes it's not. And I tell everyone that comes in with the family members, I make it a point to tell them how much I appreciate it when a family member steps forward to be a guardian for their parent, for example. It gets no publicity. It's not a really big story when that happens. But these people will stop their lives in many cases. Sometimes people quit their jobs to stay home to help their aging parent to make decisions. And it's a very heroic thing that these people do. It's a very loving thing. They get no compensation for it. They do it because they love their parent. And what I point out to the ward when they're in the court, I said, you know, you helped raise this child when the child was a baby. Now it's their turn to take care of you. And a lot of times it makes them feel a little bit better about what's happening because they feel deficient in some way. So there are different types of adult guardianships. The first is what we call a legally incapacitated person, and those are the ones I just described, usually adults who have either mental illness issues or traumatic brain injury, but the law also allows guardianships for chronic use of drugs or chronic use of alcohol, and those happen as well. The second type of adult guardianship is what's called a developmental disabled person. Again, probably the most example we get for that would be a person with Down syndrome who's an adult who, again, still can't make important decisions on their behalf. It may be any other mental impairment, somebody with a lower IQ, or, you know, a lot of different issues that happen. But if they are impaired to the extent that they cannot make good informed decisions on their own behalf, a guardian is appointed. There's also minor guardianships, and this is a situation, again, most of the time, there's many, many examples, but most of the time if a parent leaves their child with somebody else, and it doesn't mean just abandon them, it may be that they need to get their life in order. If they have an alcohol problem or a drug problem or different things, they'll leave their child with either a friend or a family member. And that friend or family member that has a child, of course, needs to make important decisions about schooling, medical decisions, and whatever. So they need to have some kind of legal authority to make those decisions for that child. And that's called a minor guardianship. And again, we have subcategories of that. It can be a full guardianship, where the parents or the other people are not available, so that the minor guardian needs to have the full responsibility to make decisions as if they were a parent, or it can be a limited guardianship. And this is a situation where the parents and the guardian actually make a contract, which says, I'm going to entrust my child to you for this time being, and these are the benchmarks that I want to have happen before we terminate the guardianship. It may be I've gone through drug treatment, or I may get stable housing that I don't have now, or that I would complete my education, or I would get my job, those kinds of things that are set forth, so that when those provisions are actually taken care of, that the guardianship can be canceled. The other thing that probate court deals with are conservatorships. They're like guardianships, but they're in situations where we're talking about the use of finances. So if somebody needs somebody just to help them with their finances, pay their bills, let's say they're in a nursing home, as one example, and somebody needs to make sure that the nursing home is getting paid every month, or that the monthly bills are getting paid if the person's living at home, it's something we call a conservatorship, where a person is appointed again to make those financial decisions for somebody who needs some help. Fourth thing that the probate court will do is mental health issues. There are people who are mentally ill that need hospitalization, at least for a short-term period of time, to get medications, to get back ready to move home. And they need hospitalization, but sometimes they are so mentally ill that they don't understand that they need hospitalization. So there is a procedure where a person will file a petition to have them involuntarily committed, and there is a court hearing for that, and that's performed by probate judges. And we do those actually here in Ingham County. They're done weekly. We have a mental hospital here, or a wing of a hospital, where we probably have between 10 and 15 people every week that are having hearings regarding involuntary admission to hospitals. We do also some things that are a little more fun in probate court. Name changes, for example, if somebody wants to change their name, we have those hearings. We mostly do adoptions, and I'll talk about the family court plan in a minute, but that's the most fun thing that I think a judge can do, is make a child, or even an adult, a permanent child, legal child of somebody else. Many times it's the result of a conclusion of a abuse and neglect case where the judge has already seen this child being abused or neglected, and then being adopted by a loving home. Again, can't get any better than that. The flip side of that, of course, is we do child protection proceedings, which most people know as abuse and neglect, where the Department of Health and Human Services is usually the petitioner, where they want to remove a child from a home. This is the flip side of adoptions, and some of the saddest cases I think that a judge can hear. I think one of the toughest decisions a judge can make is to permanently terminate the parental rights of a parent and take their legal rights away from that child and put that child in a foster home or up for adoption. There are some parents who don't care, frankly, but there are many parents who have a drug addiction or an alcohol addiction or some mental health issues, or cannot have a stable home environment, or they abuse their kids. We get doctor testimony where ribs are broken or skulls are fractured. It's a pretty horrific thing to sit through. And probate judges, in the most part, although there's cross assignments, sometimes circuit courts do it, but for the most part, probate courts hear child protection proceedings, and then it goes through a process where the parents are given services to try to rehabilitate so they can be reunified with their children, but in some cases that doesn't happen. So that probably takes up at least 20 or 25% of my docket is child protective proceedings, so that's by far the largest piece that I deal with. Probate courts, again, cross-assigned with the circuit courts, usually hear juvenile matters, and these are children 17 and under. I think it's going to be soon 18 or under. I think they're changing that legislation where we handle all the crimes that children commit, from not going to school to murder. So all crimes that are done by juveniles, there are a different set of rules, a different set of sentences that are imposed, so that the juvenile courts usually handle juvenile crimes. As far as adoptions are concerned, other than parents whose rights have been terminated, we also have like step-parent adoptions, where a child has been with let's just say a new stepfather for many years of their life. The biological father agrees or is defaulted on disagreeing with allowing the stepfather to adopt a child. So again, it makes the stepfather a real father. And there are other things that we do, and there's a lot of miscellaneous things that I think the legislature couldn't figure out where else it went, so it went to probate judges. And just to name a few of those for you, we do weddings, again, which is the fun part. Those of us that are cross-assigned in the family court also do divorces, and so I've always said I'm going to start a photo album of my weddings and then my divorces and see when they match up, but that hasn't happened yet. The probate judges are also the chair of the county election commission. Okay, that has to do with wills and trusts, kind of, not really. We do drain appeals. If somebody has a drain from the drain commissioner and there's an appeal, probate judges do that. We also do what's called DNR orders. That's not the Department of Natural Resources. It's the do not resuscitate, when people want to come in and get an order from the judge to order the doctors not to resuscitate someone. And again, as Michelle Rick pointed out, we do a lot of times family court duties. Most courts have combined the probate functions and the circuit functions, and the philosophy is a one family, one judge concept, so that if you have an adoption and then later if there's a divorce, or if there's a parenting time issue, or if there's child protection issues, those can be handled by the same judge, and they're not going from judge to judge. Because most people, when they walk into the courthouse, I believe, don't have any idea of the difference between a probate court, a district court, and a circuit court. They know they have to go to court. And I love the new philosophy of combining and cross-assigning courts so that it's much more efficient for the people. They know which judge they're assigned to, and those matters are handled as well. The last thing I wanted to point out is every courthouse, every county has administrative duties. A judge's functions are not only to sit in the courtroom and make decisions. There are a lot of administrative duties that go along with that, and most counties, all counties, have a chief judge assigned either to one court or to the whole county now, where the chief judge has to deal with administrative issues like case assignments, which judge is doing which case, the budgets for the courts, working with the funding unit, which is usually the county board of commissioners, and dealing with court operations as well. And so the chief judge in the county, or for the court in a larger court, has to deal with all those issues of administrative nature that the public don't see, but are very prevalent. So thank you very much.
Thank you very much, Judge Byerley. Before we move on to our next segment, we do have about a minute or so, and I do have a question that was tweeted, and it's hoping that one of our judges today could discuss the parameters of live tweeting court hearings in which there are sequestered witnesses. I'm not sure that's something we might be able to deal with right now. We might have to kind of put that in writing and get back to the questioner. Okay, we'll do that, and so we'll watch for that in your email. We'll address that question later on. So at this point, we'll move on to the most exciting portion of our first segment for those of us in the appellate system. And our first speaker, we're talking about their appealing, the Court of Appeals in the Michigan Supreme Court. We're going to hear from the Chief Clerk of the Michigan Court of Appeals, Jerry Zimmer.
Thank you, John. As he said, I'm Jerry Zimmer, Chief Clerk of the Michigan Court of Appeals. I'll just give you an overview of the court and then make a few points about that might be helpful to the media. The Court of Appeals is the state's intermediate appellate court, meaning we have kind of the general appellate power over the trial courts, the circuit court in particular, but also certain state agencies. but we're subject to the appellate jurisdiction of the Michigan Supreme Court. The Court of Appeals then is the initial venue for most appeals from circuit court, again, and the tribunals that come from the state agencies. This includes criminal, civil, family cases. When a party in a trial court believes that the court has made an incorrect ruling or disagrees with that, the party may file an appeal to the Court of Appeals. And then from there, the Court of Appeals decision may be appealed to the Supreme Court. The Court of Appeals essentially handles two types of appeals: an appeal of right, meaning the party has the right to an appeal in the Court of Appeals and we must hear it. The other type is an appeal by leave. The party comes to the court with an application for leave to appeal and asks the court to grant them an appeal. They don't have an appeal of right in that situation. Appeals, in that situation, the court early on issues an order that either grants or denies that application. That typically happens within the first 3 to 5 months. Probably nearly 3/4 of the cases that come by application are denied by the court. So those cases kind of open and close fairly quickly, 3 to 5 months into the case. But for appeals that are where leave is granted or by right, the case progresses through a series of stages. We wait for the transcripts to be produced in the lower court. The parties are then put on a timeline for filing their briefs with the court. And after that, oral argument is scheduled. At the end of the process an opinion is issued that decides the case. The length of time for that process is varies considerably depending on the type of case, but on average 15 to 16 months from the time it's filed. The Court of Appeals is an error-correcting court, meaning that it's focused on the dispute between the parties and looking to correct any error the trial court made, rather than making case law. That's an offshoot of what we do, but the main point is to correct any errors that might have happened in the trial court. It's not an opportunity for the parties to retry the case. They come to the court to have a panel of judges review what the lower court judge did and determine if an error was made, and if so, what the proper remedy for that error would be. The party filing the appeal is known as the appellant. The appellant is required to file a brief early on in the case that identifies the issues that they would like reviewed by the court. The opposing party, known as the appellee, can file a brief in response. They aren't required to do so, and if they don't, the case proceeds with just the appellant's brief. After briefing is complete and the lower court file is received, the appeal is assigned to a panel of 3 judges for oral argument and decision. At oral argument, the attorneys for the parties are given an opportunity to reiterate the points they've made in their brief and answer questions from the judges. No witnesses are called or evidence admitted because the appeal is limited to the record of testimony and evidence that was presented to the trial judge below. Oral argument typically lasts about half an hour, and it is the only live proceeding that happens in the court. All other aspects of the cases are done through written filings and orders and opinions. Generally, the panel releases its opinions 2 or 3 weeks after oral argument. Either party may file a motion for reconsideration with the court if they believe some aspect of the opinion was an error. A party may also file an appeal to the Michigan Supreme Court within the required time limit. But the release of the opinion essentially closes the case in the Court of Appeals. The court receives roughly 5,700 cases a year. Just under half are criminal appeals. Those are overwhelmingly criminal defendants who are appealing their conviction and sentence. And about a quarter of those are plea-based convictions. And those come by appeal by leave. The defendant needs the Court of Appeals to grant them an appeal in those situations. Civil cases make up the other half of all appeals, and they run the full gamut of family law, contract cases, probate cases, but about 1/5 are family law cases that involve termination of parental rights and child custody. Of the thousands of cases filed in the Court of Appeals each year, a very small number generate any media interest, possibly 2 or 3 dozen a year. Some high-profile criminal cases from time to time, murder cases particularly that have, some aspect that made them newsworthy. Civil appeals, often it'll be an election case or, some governmental type of case. We get those, again, just a few a year. If you're interested in any case that's pending before the Court of Appeals, you may call the clerk's office and we can give you general information. You can arrange to come and view the court file and get copies of documents from the file. But the Public Information Office of the Michigan Supreme Court, they handle most of the media contacts for Court of Appeals cases and the Supreme Court. And the clerk's office for the Court of Appeals keeps that office updated on high-profile appeals. And any time a filing is made or an order or opinion is issued, we let them know right away, and they often disseminate that within minutes of the time we get it to them, to their media sources. As I mentioned, the only live proceeding in the Court of Appeals is oral argument. Everything else is handled in writing. The courtroom is open to the public, and you may come and observe oral argument, take notes, sit through the proceedings. But if you do wish to record with either audio or video, you will need to file a media request form, and that form can be found on our website. It just takes a couple minutes to fill out, and you can file it with the clerk's office. You can fax it in to us, or you could call the clerk's office and email it. We'll give you an email address to send it to. But that request needs to be approved by the panel of judges that will hear the case. You'll get an order that approves the request. Beyond that, that's all I've got, and if you've got any questions, I can answer them.
Super. Thank you very much, Jerry.
All right.
If you have a minute or two in your segment, if you've got a question about the Court of Appeals. All right, then now we'll move on to hear from the Chief Supreme Court Clerk and Chief of Staff, Larry Royster.
Good morning. I'm relatively new to this position. I'll have 3 years in May, so I am still learning very much about it. But I'll try and give you an idea of just the process of from filing to decision and some information about the court makeup. In terms of the actual decision-making process, I know Justice Viviano is speaking after the break, so I'm going to leave that to him to go into any detail on that. As I indicated, I am new, but fortunately for me, my predecessor, Corbin Davis, who I believe started as the clerk of the court in 1974, he still works at the court in the position of the reporter of decisions. So I have the benefit of just picking with the phone and calling him if there's questions. So if you call this office and I put you on hold, you'll know what I'm doing. But in terms of the makeup of the court, there are 7 justices. Behind me you can see the 7 chairs and the name placards. If you're in the courtroom, probably online, it's hard to make out the names. But we sit in panels of 7. All decisions, with rare exception, are a 7-justice decision. The way they are seated by tradition, the Chief Justice, of course, sits in the middle, and the current Chief Justice is Robert Young. And then they go according to seniority to the right, to the left, to the right, to the left, to the right, to the left. So Justice Markman, to the right of Chief Justice Young, is the next most senior, and then Justice Czar on his side. And the newest member of the court, Justice Larsen, who introduced the session, is at the far left. And I'm not sure you can see that with the monitor in the way there. The actual decision-making process is actually done in a conference room that's just to the south of this. There's a hallway that runs behind the courtroom, and there's a large conference table there. And for reasons I still don't understand, the seating order there is completely different. They sit in terms of seniority going clockwise. So the Chief Justice is the head of the table, and then to his left, again going clockwise, they go in terms of seniority. So whenever we get a departure or an addition, there's a little bit of musical chairs that goes on, both in the courtroom and in the conference room. The Chief Justice is selected by his colleagues every 2 years. Again, Chief Justice Young is the current chief, and he is in the 2nd year of his 3rd term. Whether he will get yet another term or not, I'm not sure. I'm not privy to that information, but again, it's by majority selection of the justices themselves. The justices are seated in one of two ways, either through election or appointment by the governor. They sit, or their terms are generally 8-year terms. Fortunately for Michigan, we don't have an advise and consent requirement like the the U.S. Supreme Court does in terms of the Senate. So when the governor makes an appointment, that person is seated. If they are filling a unexpired term of their predecessor, they would have to run in the next general election to serve the remainder of that predecessor's term. So I think in the situation of Justice Viviano, he had to run for a general election to serve out an additional 2 years and then run for the next 8-year cycle. So the 8 years is only if it's a vacancy that had fully expired or they are appointed coincidentally at the end of someone's term, and they would run in that general election to serve the next 8-year term that would have been served. The court sits in terms. The term runs from August 1 to July 31, and really that has no significance except for one reason. If there are any calendar cases, and I'll explain what that means in a minute, if there are any calendar cases that are undecided at the end of the term, being July 31, then by court rule, the parties can file supplemental briefs and they can request re-argument of the case. So for that reason, the justices really do not like not making decisions in calendar cases. They will make every effort. In the time that I've been here, it's never been a situation where they have not been able to decide a calendar case by July 31. There have been several instances where an opinion has been issued on July 31, but they have done that. There are other types of cases that are argued. The calendar cases, what that means is it's a full leave granted, and it's fully briefed again. The parties have 30 minutes of arguments on each side. If both sides are endorsed, if only one side is endorsed, it's 15 minutes, so it's a very short argument in that situation. Another type of case that is argued is referred to, the acronym is MOA. It's a mini oral argument on the application. As an aside, one of the hardest things that I had to adjust to was the use of acronyms in this court. There are all sorts of acronyms, so I apologize if I start throwing those out, and I'll try to explain what those mean as I do, but there are a lot of acronyms the court uses, and MOAs are those cases where they are undecided whether that really deserves a full consideration of the court. And they do not have the requirement of deciding those by the end of the term. The argument times are cut in half, so there's 15 minutes argument if both sides are endorsed, 7.5 if only one side is endorsed. And the decisions that are made by the court after the mini oral arguments can run the gamut. They can deny the leave application and say thank you for the arguments, but after hearing them, we really don't think there's anything we want to address. Or they can issue full opinions. In contrast to the Court of Appeals, the Supreme Court is not an error-correcting court. They are looking for cases of jurisprudential significance, meaning that they would affect more than just the single case. They would affect a wide range of cases. The bigger issues that face litigants in the state of Michigan. One example was a case heard last term dealing with the juvenile lifer cases, and that resulted in, most recently, a U.S. Supreme Court decision that held it unconstitutional to have a mandatory life term for somebody who's under the age of majority. This court, it was a combination of 3 cases. One of those cases was appealed to the U.S. Supreme Court, and the decision was recently made in that case on that. The vast majority of the cases that are appealed are not by right, again, in contrast to the Court of Appeals. They are by application for leave to appeal, which means they're discretionary as to whether the court takes them. Again, the court is looking for bigger issues. Oftentimes, I can tell you in the discussion at conferences, they'll recognize or believe an error was made, but just don't feel it's significant enough to require oral argument or for them to get involved in it. And if that's the situation, the court will just issue an order, and it has boilerplate language to the effect something like failure to persuade the court of the need to review the questions that were raised, something along that lines. That is by far the most common type of disposition by the Supreme Court. The court hears arguments usually on the first Tuesday, Wednesday, Thursday of the month, if it's a full week month. If it's a partial week month, it may be into the second week. And they hear arguments starting in October through May, with the exception of February. February is an off month, so they can catch up on some of the other paperwork that they have to deal with, as well as the opinions that are circulating in the cases that were argued in the previous months. Oftentimes, it will not be full 3 days of arguments. It just depends on how many cases are fully briefed and ready for argument. The last couple case calls we've had have only been 2 days. If it's a 2-day call, it usually will be held on Wednesday and Thursday. If it's a single day call, it will be held on Wednesday. And that's not coincidental either. Wednesdays are their conference days, so they know generally every week they would be scheduled for a conference anyways. So rather than doing perhaps a 1-day call on Thursday, they would have been in conference on that Wednesday. So Wednesdays for them are sort of always blocked off for some purpose. The cases, as they're argued, are live streamed from the court, so you can watch them from your computer. After oral arguments, within a day or two, they're posted on our YouTube website, and the state of Michigan, the Bar Association also posts the archive arguments on their website. I believe they take those down after a year, though. So if there's an argument from perhaps a previous term that you wanted to see, it probably will be on our YouTube website, but not the State Bar of Michigan website. We get probably about a third of the filings of the Court of Appeals. So Jerry had indicated they get just shy of the 6,000. I think it was 5,800 around this past year. We get around 2,000. That has fluctuated, give or take a couple hundred in the past 5 years, but generally 2,000. Most of those are the leave applications, vast majority of them, 97%. The other types of cases are original actions. That is, they weren't an appeal from the Court of Appeals. They were filed initially in this court. And types of cases that would be actions against an attorney that the Attorney Discipline Board has taken, or perhaps a disgruntled client of an attorney that the Attorney Grievance Commission has not chosen to take any action against. So the individual who grieved the attorney would appeal or file what's called the superintending control action with the Supreme Court. We also have some unusual types of cases, one of which is called a certified question. That's where a court from within the state of Michigan or outside, another state court or federal court, wants a decision from the Michigan Supreme Court on a question of law. And rather than them decide it, they would say, Michigan Supreme Court, please let us know how you would decide this. And we have one of those cases currently. It's a case that will be argued as part of our Court Community Connections program at the end of April. I believe that's being argued in Jenison, Michigan. And more information on that can be obtained from the Public Information Office. But that is a certified question from the Ninth Circuit Court of Appeals, U.S. Circuit Court of Appeals. But it also could generate from an in-state court as well. Another type the certified question that I just mentioned is the only one that I've seen in the 3 years that I've been here. Another type of case is called an advisory opinion. I've not seen any of those, and I don't know how long it has been, but it's a mechanism at which the legislature or the governor can ask for a ruling on the constitutionality of proposed legislation, or if before a governor signs something that's been passed by both houses, whether it's constitutional before he actually signs. So it's just, again, it's a very limited thing, and like I said, I have not seen those, and it's been many, many years since we've had any. Of the 2,000 filings that we get per year, about 30% are criminal, or excuse me, other way, 30% are civil and 70% are criminal. The vast majority of the criminal are self-represented litigants. That is, they're here without having an attorney. About 25% of the civil cases are also self-represented. And that is, in the criminal side at least, that is because there is no right to have an appointed counsel for you at the Supreme Court. You have a right in most situations to appointed counsel at the Court of Appeals if it is the first direct appeal that you have taken in your case. The U.S. Supreme Court, in a decision called Gideon, had decided that you have that constitutional right to an assistance of an attorney. But because the appeal to the Michigan Supreme Court is the second review of that case, you have no right. So a lot of times they will just represent themselves using perhaps the brief that was prepared by the attorney on their behalf at the Court of Appeals. They have an opportunity to add to it, raising additional issues or pointing out additional facts or whatnot, but it is something that they would represent by themselves. If by chance that case was identified as being jurisprudentially significant and the court wanted to actually hear arguments on it, we'd arrange through perhaps SCAO or another attorney to volunteer to represent that individual to argue. So the self-represented litigant will not actually come to the court and argue behind the podium to the justices. We do have electronic filing at the Court of Appeals, or at the Supreme Court. It's relatively new for us. The Court of Appeals have had it for many years. But starting in January of 2015, we started with an electronic filing system. So you can still file hard copy, but we are the only location of the Supreme Court in the state of Michigan, so it's much more convenient for somebody to electronically file than it is to perhaps drive from the Upper Peninsula to the courtroom to actually file the documents or to mail them in and take maybe 3-4 days of your actual briefing time, your writing time away in order to get it to us in time. The filing deadlines are absolute. So if you miss a deadline by even a single day in filing, there is no opportunity for review. It's rejected at the clerk's office and it never goes to the justices themselves. So it's critical for us that everything is filed timely, and the electronic filing system has been, I know, used quite a bit at the last minute even. So if you get your documents in by 11:59 on the day they're due, 11:59 p.m. on the day they're due, we accept them as being filed that day, and we'll docket them as when we get in the office the next day. There's nobody actually in the office to accept them, but we'll docket them as being timely filed if we get them in by that time. The process for the cases coming to the court, everything starts in the clerk's office. So whether it's by electronic filing, it's received by mail, or somebody delivers something over the counter, we'll accept it, docket it. We do a quick jurisdictional review just to make sure, again, it's timely filed and everything is in order in terms of what we need under the court rules. If there are any problems with it, if short of being late, if it's late, again, we reject it. But if there's any problems, we'll ask the people just to correct them, and then we'll push them on to the commissioner's office, who do a report for the justices, and then the justices take over for their decision making. And I guess I'm seeing the blinker for me, so I'll wrap it up there.
Thank you very much, Larry. Now our next speaker, representing the State Court Administrative Office, is one of our regional administrators. And just briefly, I could mention that we have 5 regions, and you're probably going to touch on that. And so our Region 2 administrator, Jodi Latuszek.
Okay, I hope you can see me. I feel like I need a stool. I wasn't going to start this way this morning, but you know what they say about good intentions. I want to tell you about a professional development opportunity I had this week. I went down to Atlanta and had a training with a group of 8 people, management leaders from all over the country, but not from the courts. And a nice woman, she asked me, "What do you do?" And I said, "I work for Michigan's State Court Administrative Office." She stared at me. She said, "Okay, well, what's that?" I said, "Well, we're the administrative arm of the Michigan Supreme Court." And she gave me this look, and instantly I was transformed back to being an 8-year-old child and having my very southern grandma look at me and say, "Bless your little heart." Our conversation quickly turned to a discussion of the weather. And then I felt horrible. I missed an opportunity. I felt like you must feel when you miss an opportunity to break a story. I mean, we do important work here, and I could have shared it, and I didn't. So on the plane ride home last night, around 11 p.m., I'm thinking, if I can't tell this important story to this very, very nice Southern woman who reminds me of my grandmother, what am I going to do to convey this story to a group full of zealous, talented, professional journalists? And then I remembered that on the banks of the Red Cedar, there's a school that you all know where I took classes in communication arts. And I remember that journalists operate in a world of who, what, where, when, why, and how. And what I didn't do is put myself in the shoes of a journalist. I didn't convince my editor, I didn't convince this woman of why she should care about the story. Because, I mean, if you can't get a story published, why would you tell it? So, I'd like to start by telling you the why today. The story of the Michigan courts. Michigan is made up of 83 counties, broken up into 57 judicial circuits, as you heard. And that's 562 trial court judges who work in 243 courts. Together, these courts have about 500,000 cases pending at any given time. And the decisions of the courts include things like decisions on traffic tickets, decisions to incarcerate individuals, to terminate parental rights, as Judge Byerley said, but to reunify families, to find children forever homes, to enforce contracts, to enjoin action, to clarify rights, to settle estates. The point here is that they're important. No matter how big or how small each case is, it matters to members of the public, the people who read your stories. And it's a lot of work. A lot of work goes into making these decisions that are so impactful to the public. And the reason I'm belaboring the point is because this morning, Justice Larsen talked about the additional things that courts have to do. The day job, the 9 to 5, is making these important decisions. But as Justice Larsen said, and as Judge Byerley indicated, there are administrative functions of the court as well. Courts are expected to adjust with rapidly changing times, changing populations, to innovate, to enhance service to the public, to meet time standards and guidelines, to be the best courts they can be, and to be measured and good public service. And they shouldn't have to do it alone. But the why is that they don't, because they have the administrative arm of the Supreme Court to help them. And as Paul Harvey would have said, that's the rest of the story as to why. So now that we have a little more about the why, let's talk about who. Who is SCAO? Who are we? I'm just a regional administrator with the State Court Administrative Office. The State Court Administrative Office, or SCAO, is numerous divisions of talented people with specific expertise in different areas of law and administration. For example, we have 5 regional offices. We have divisions like trial court services with expertise in specific legal areas like district court, circuit court, probate court, but also in court functions, language access, and court administration. We have child welfare services that also includes our Friend of the Court Bureau, and they help set policy on child welfare cases and ensure that courts are enforcing best practices with regard to children in our state. We have Friend of the Court Bureau, and their expertise is in Friend of the Court, obviously, but in child support and making sure that our courts are meeting federal standards so that they can maximize the federal dollars they get to help families. We have alternative dispute resolution services that help with mediation programs around the state. We have a finance and budgeting team that not only makes sure that courts are following rules and regulations, but helps courts be better at meeting their budgets. We have a statistical research team, and you'll hear a little bit about that because a lot of what we do now is we measure. We measure how courts are performing, not to just monitor them and tell them they're doing good or bad, but to help them inform their practices going forward. And I think Stacy Westra from Trial Court Services is going to talk about how that research and data translates into our performance measures initiative. We also educate the public as well as attorneys and court staff. Much of that is done through the Michigan Judicial Institute, which is also considered part of the State Court Administrative Office. Additionally, we have judicial information systems. They're the technical folks, the computer guys, the guys who make it all happen. Well, men and women, sorry. But these divisions, all working together, and sometimes independently, do the following things. They collect data and analyze and work on improving court performance, mediate disputes, often with funding units, other branches of government, review and approve local administrative orders through the regional offices, provide technical assistance, including assistance in computers, software, and hardware. We talked earlier about efficiencies and concurrent planning and right-sizing the judiciary. But that's not always easy to do. And so one of the things SCAO does to help courts do that is we'll go in, because the courts don't have to do it alone, and we'll look at what the court's doing. How are the documents moving? How is the public served? And how will you do it with fewer resources or using resources in different ways? And we'll provide them a report, we'll have meetings with them, and we'll help through implementation to make it work easier for the courts. We provide really any assistance that the courts need. It's a problem-solving role, and sometimes it's easily defined, like reviewing administrative orders, issuing concurrent plans. But sometimes the problems are unique. Sometimes they're things we've never dealt with before. But we do what Judge Rick said. We partner with the courts, strategize together, and use the resources. So sometimes solving a problem in your court, Judge Rick, might mean that we need Friend of the Court Bureau and Trial Court Services to work with the regional office as a team and work with you to come up with a solution. And sometimes maybe it's just a computer issue. Well, not just a computer issue. But sometimes it's an issue that's just technical in nature, and so it would be judicial information systems that answers it. The point is that there are so many resources here available to help each court so that they don't have to do it alone. But just as important as understanding what we do at SCAO, it's important to understand what we don't do. Although we investigate litigant complaints related to court process, we don't do criminal investigations, and we don't make decisions in individual cases. That's for our jurists to do. We can't make judges rule a certain way, nor would we want to, because they're afforded deference in their decision making, as well they should be. We don't give legal advice to litigants. Although the organization is full of talented attorneys and knowledgeable people with legal resources, we absolutely do not advise in individual cases. We have no licensing capacity, so if somebody calls and says, well, I think this attorney should not be licensed, they didn't do a good job for me, we can't do anything about that. We're not a child placing agency, although we have a child welfare services organization. Sometimes that's very confusing to people. People call and talk about placements of children. We don't have anything to do with that. We can't remove judges from the bench or from the office. There are other procedures for doing things like that. So there's a list of things we can't do, but there sure are a lot of things we can do. The one I'm missing here, I think, is where. Where do we do it? Well, obviously, we have offices in Lansing in this building, the Hall of Justice. We also have offices in Detroit, Gaylord, and Mount Pleasant. But the real answer to that where is everywhere and anywhere the courts need us. The 83 counties in Michigan, unfortunately, aren't all conveniently located within an hour of Lansing, which means you might find analysts from the SCAO in Monroe one week, in Gogebic and Ontonagon the next week. For those of you not familiar with the difference there, it's about an 11-hour drive between the two. But the point is, we go where the courts need us. The business of the courts is in the courts, and that's where. When? Ongoing. Our work is ongoing. In the regional offices, for instance, we're traveling, we're in the courts 3 to 5 days a week. And the problems vary. It's different. There's always work to do in the courts. There's always measurement. There's monitoring. There's strategizing. So it's an ongoing job. And the how, I answered that. It's through data collection, through teaming with the courts, through combining resources. But really, at the end of the day, it's through listening. The interesting thing about SCAO and how we work and where we work and going into the courts is that, yes, we have statewide policy initiatives, performance initiatives that you'll hear about today, specialty court programs, time guidelines, things that we go out and tell the trial courts. But when we're in those courts, we listen to the feedback the courts give us. Now, most of the time, it's very positive, and we love what you're doing at SCAO. But a lot of times, it's constructive criticism, and we take it back to Lansing, and that helps drive our procedures and our performance, because we're accountable too. So again, it just reinforces what Judge Rick said. It's collaboration, it's partnership, it's working for the courts, so not only can they provide excellent service in 83 counties and 57 circuits, but to every single litigant who walks through the courtroom doors. And they don't have to do it alone. Questions? Thank you.
Thank you, Jodi. We're going to take a short break, but before we move off to that break, two things. One is I want to thank all of our presenters. This has been really educational. I'm still, as Larry's kind of a newbie up in the clerk's office. I've only been here 2 years, so it's been a great education for me. The second thing is we do have another question from a journalist in Detroit who I'm hoping if one of our judges on the panel could answer, and that is, what are the parameters for keeping a camera out of the courtroom? If you could explain how does that work, and why, and when, and how would you keep a camera out of the courtroom? Is that something you might be able to address, or if you could step up to the podium real quickly, and then we'll take our break after that.
I think we'd indicated before that all the court proceedings will be public in nature. There may be some issues, though, about taking photographs of a particular victim, or there may be some undercover officers that maybe the judge makes a determination that they don't want a photographic record of that. We've had some concerns in the district court lately with people with cell phones, and they've come in and they're trying to hide them underneath and taking pictures of either victims or police officers, so that the judge could make a determination in those kind of situations that they would not have cameras in the courtroom, and for those reasons that they have stated. So those may be some particular situations where the judge has made a determination that they are not going to have cameras in the courtroom, or will make a specific order that the camera can be in here, but you're taking pictures of other folks and just not taking that victim's photograph, or not taking the particular that particular witness. You may be able to do it for other purposes.
Great. Thank you very much, Judge Alderson. We'll now take a short break. We will reconvene at 10:40 with a behind-the-scenes look at the Michigan Supreme Court and how it makes decisions with Justice David Viviano. Thank you. Always wanted to do that. Welcome back to the Michigan Supreme Court and State Court Administrative Office Law School for Journalists. We've had some really great presentations already today, learning about all the different kinds of courts and what they do in those courts. We've learned about the Court of Appeals and the Supreme Court and how the appellate process works. And we've learned about the State Court Administrative Office and what it does and doesn't do. And now that we're back from break here at Law School for Journalists, we're ready to hear about how the Michigan Supreme Court operates, how it makes its decisions, a little bit of a behind-the-scenes look at that process. And joining us today to talk to us about the Supreme Court is Justice David Viviano. Justice Viviano.
Okay, thank you, John. Good morning, everybody who is here in the Supreme Court courtroom and those of you who are watching remotely. We appreciate your interest in how we conduct our affairs, and it's a great opportunity for us to talk a little bit about how things happen behind the scenes. Even in my days as a trial judge, it's sort of interesting how little interaction judges are able to have with the press. So this at least gives us an opportunity to talk more broadly about how we conduct our affairs. And in particular, I was asked to talk about how we make decisions here at the Supreme Court. And so I don't have a lot of time, and so we'll just move right on into it. Our consideration of cases really happens at 3 stages. First, at the application stage, where the parties are asking us to hear their case. Unlike the lower courts, we're not obligated to hear every case that comes our way, and in fact, we turn away most cases, and we spend an awful lot of time making that initial decision on which cases we're going to spend our time and resources thinking about and ultimately issuing full-length opinions on. As we progress to the next stage, once we decide that an application bears further scrutiny, it proceeds to the conference stage, and that means that one or more justices has decided that this case should be looked at by all of our chambers together. And so we'll spend more time within each of our chambers, and then also talking together as a court in private at conference to discuss whether or not we should grant leave or take other action on a given case. And then, of course, the third phase, which all of you probably are more familiar with, is the oral argument phase. Once we've decided now this is a case that is deserving of attention from the state's highest court, then we'll ask the parties to submit briefs after we highlight the specific issues that we are interested in. So our grant orders really will be a message to the parties and to the public and to all of you on which of the issues in the case we are most interested in. And so the parties will have an opportunity through briefing to discuss those issues. Sometimes we'll invite briefing by amicus groups, outside groups who may be interested in the outcome of the case. And then we as justices will spend even more time now at this third stage learning about the case and thinking about the case and preparing for argument before we ultimately meet after oral argument in chambers and take a vote and see where the votes are and how a case may come out. Although ultimately, it's interesting, the voting in the case can change all the way up to the point where an opinion is issued, and I'm here to tell you that sometimes that happens. The initial straw votes aren't always the final vote on the case. One interesting distinction for me from my time as a trial judge is that this is really a two-step process deciding a case at the Supreme Court level. When I was a trial judge, whenever you reached your decision on a case and issued it, either from the bench or in writing, the case was decided and the issue was resolved. Now, of course, as I talk to my new clerks when they come in, getting the right answer in our chambers, while extremely important, is only half the battle. Then the rest of the battle, of course, is trying to convince a majority of my colleagues of the correctness of the result that we see in a given case. And so we don't stop just when we find out what we think the right answer is in a case. And there's a bit of advocacy that goes on a multi-member court. You know, you see the 7 chairs behind me. So, you know, we need at least 4 people to agree in most cases for us to take any action at the Supreme Court level. And so, we rely on our skills, interestingly, as that we learned as lawyers and as advocates to be persuasive with our colleagues. And that happens really throughout the life of the case. We do a lot of business on our court by email. We do a lot of business by memo traffic. There's a lot of substantive, they're obviously private, non-public, but substantive memo traffic amongst the justices and amongst our chambers as we discuss issues that arise or may arise in a given case. We have informal conversations amongst ourselves, of course, leading up to argument, for example. Those can occur. And then we conduct our official business in conference when all 7 of us are assembled to discuss the case after oral argument. And so hopefully that gives you a little bit of a sense of how our decision-making goes. We are fortunate on our court that we have, that the court is a collegial group of people. And so people are working very hard and challenging each other, and we have a very open and robust discussion of issues on our court. And, as we heard, we saw when Justice Scalia passed away, and his good friend Justice Ginsburg was talking about their relationship, both personal and professional. Noteworthy, I think, for our purposes on the professional side, when Justice Ginsburg talked about when Justice Scalia would send a dissent to her, and she would look at it, it always strengthened her majority opinion. And that's really true in the way that we do business. The better and more substantive a dissenting opinion is, the more the majority has to think through those issues and really make sure that if you're in the majority, that you're addressing those issues. And so it really strengthens the majority opinion in a case. And ultimately, our goal is to bring clarity to the law in Michigan. The more that we can achieve consensus on our court in doing that, the better. But we are a court of multiple members, and we do vote, and sometimes there are differences of opinion. There are dissents. There may be concurrences, justices who agree on the outcome, but not on the reasoning that leads to that outcome. And we have the ability, of course, to express that in writing. So I hope that gives you a little bit of an idea of how the court functions. I don't know if we're able to answer questions. I'm happy to do so if that's part of the process. John?
If we have any questions in the room, we can certainly welcome them. I actually have a question, Justice Viviano. When you since you've joined the court, what most surprised you? Because you've been a judge obviously for very long, you've been a chief judge. What most surprised you in becoming a justice?
Well, one of the things that I still think is a little counterintuitive is something I already mentioned, which is as a trial court judge, you have to handle every case in some fashion that comes before the court. And people don't leave your court until you give them a decision on a case. And at our level, we don't do that. We don't take every case. We don't view ourselves as an error-correcting court. Ever since the Court of Appeals was instituted in the 1960s, that became their job. They hear a larger volume of cases, and they are there to correct errors that the trial court makes. And so it's a little counterintuitive. Most lawyers are perfectionists. I think I have a little bit of that in me as well. And so it's hard to let cases go if you think not every issue was handled perfectly. But the role of our court, just like the U.S. Supreme Court, is to really only get involved in cases that have what we call much broader jurisprudential significance, importance really to all of our citizens in Michigan, and to spend our time and resources finding areas of the law that have become confused or where the lower courts are having trouble understanding the law, where our citizens are having trouble understanding their obligations under the law, and where we can bring some clarity.
Super. Thank you very much.
Okay, anybody else?
Yeah.
All right. Yes, sir.
How often do you have like a 4-3 split among justices, or is it usually, kind of one-sided, or is it split a lot?
If I could repeat the question for the folks that watching so that he doesn't have a mic.
Sure. The question was, how often do we have a 4-3 split? Does that occur frequently, or are we able to achieve broader consensus more often? There are, at the end of every term, studies are done to look at how often we come out, how the different majorities are made up, and how often we achieve consensus in a given term. And I think you will find in recent years we have had fewer 4-3 opinions and more either unanimous or near unanimous opinions. Having said that, usually by the time cases get to us, the issues are very close issues. They're difficult issues. They're issues that the lower courts have struggled with. The Court of Appeals, and a lot of times there'll be a split opinion, a 2-to-1 opinion on the Court of Appeals, and so they're close questions. So I don't mean to suggest that that a 4-3 opinion, that there's anything wrong with that, because we don't get a lot of easy cases at our level. It's just sort of the way the court system works. But as I mentioned already, our job is to bring clarity, and when there's a consensus of the 7 of us as to how a case should come out, I think that's a really a good thing.
Terrific.
All right, thanks, everybody. Have a great rest of the day.
Thank you. Now, our next speaker at Law School for Journalists is going to address the Supreme Court's rulemaking function. If there's anything, we love rules around here. And speaking on this issue is the Administrative Counsel for the Supreme Court, Ann Boomer.
Thank you, John. So the best way to think about rulemaking in the Supreme Court context is there's cases, which Justice Viviano just talked about, and then there's everything else, which is really the rulemaking function. Under the Constitution, the Michigan Supreme Court has the authority to establish, modify, amend, and simplify the practice and procedure in all courts of this state. So what that means typically is court rules. And there are separate chapters for court rules of every different type of court. There are rules on civil procedure, special proceedings like juvenile child protection, domestic relations, district court, probate court, criminal procedure, rules of evidence, administrative orders, local court rules, and appellate rules. And these are all included in this book here. But there's so much more. There's disciplinary rules for attorneys and judges. There are rules of professional conduct, which are essentially attorney ethics rules, and there are judicial canons, which are judicial ethics rules. There are rules for the Board of Law Examiners. So really, it's so much more than just what happens in a courtroom on any particular day in a particular case. So being a rule-based operation here, there are rules about how to amend the rules. MCR 1.201 and Administrative Order 1997-11 both set out the general process, but as opposed to the way that cases are handled here at the Supreme Court, we try and have a very transparent and participatory relationship with the public when it comes to rulemaking. The general process is the court will consider a proposal, and if it believes that it's an important thing to ask the public about, it will publish for comment a proposed rule, and the proposed language is shown in strike-through and underlining so that you can see the existing rule along with what the proposed change is. Public comment period is at least 3 months. During the public comment period, all comments that are submitted to the court are posted on the court's website. So everyone who comments and goes to the website can actually see what other people comment as well. And really the most effective advocacy is when a commenter says, well, you know, I'm piggybacking off of what another commenter said. So there's a lot of that discussion that goes on. So after the public comment period, the issue is placed on a public hearing agenda. So 3 times a year, I'll be sitting right there where Mr. Vailliencourt is sitting, but I'll be standing on the other side of the podium. People can come to the courtroom and verbally give their comments about the issues that are before the court for adoption. And then after that hearing, they'll go into conference and decide what they're going to do, and then issue an order. So at that point, the court can take a variety of actions. It's not just adopt or decline to adopt, although those are the 2 most common outcomes. They might adopt the rule that was published with some changes based on the comments that were submitted or based on internal discussion or based on, you know, whatever the discussion happened to be at the table. They might delay consideration of adoption of a final order to get input from an outside agency, another entity. You know, they might need more information. What sometimes happens is if during their discussion they decide that they actually want to do something that's quite a bit different than what was published, they sometimes will actually republish so that they don't adopt something without knowing what the public thinks about it. So those are some of the outcomes that can happen. If the court adopts an amendment, it typically will go into effect several months later so that people have a chance to know what the change is and be aware of it. Now, as with every rule, there's an exception. Sometimes a statute will change and all of a sudden the court rules are in conflict with a statute. So what can happen in that case is the court will adopt a change in compliance with the statutory change, but in those cases the court will still have a public comment period. The issue will still be placed on a public hearing agenda so people can still comment both in writing and orally. And then what happens at that point after the public hearing is the court will decide whether to retain or not the amendment that it adopted previously. So one of the things that really separates the way cases are decided and the way court rules are managed is trying to get the public involved and trying to make sure that people know what's going on in the court rule world. And we've structured the website to provide for that and to foster that. First of all, we have a special page devoted to proposed court rules and administrative orders, and the way that it's set up is when the court publishes something for comment, the order that lists the amendment is the first clickable link, and then after that are listed all the comments, and then the public hearing date is inserted when that's known, and then whatever the court decides to do eventually, the final order is also posted. And those materials are listed on our website for at least a year. So if you ever want to know, gosh, what did the court do in that particular case, you can always go back and check. And if for whatever reason they've been taken down, only because, you know, we try not to lard up our website too much, you can always call my office and say, you know, what happened. I'm happy to share orders, comments, anything that we have that's a public material is always accessible. The other way that we try and keep people apprised of what's going on is we have a listserv that if you are signed up for, you in your inbox every day that an order is issued, you will get a copy of whatever orders related to administrative matters. So, you know, typically the court meets about once a month to discuss administrative matters, and the orders that come out of those conferences typically enter the following week. So on that day, you might get 5 or 6 orders, and you know they'll all be the separate orders that will show the proposed court rules. So if you sign up for that listserv, just go to our website. You too will be apprised of everything the court does administratively. And the only other thing I really wanted to focus on is there's, I think, a perception that when the court publishes something for comment, that it's sort of pre-decided, that whatever is published is definitely the way they're going to go unless there's some really bizarre thing that happens. And I cannot tell you that more vehemently that is definitely not the case. When the court publishes something for comment, it really is eliciting comment. It wants to know what the public thinks. It doesn't want to do something that's going to have unintended consequences. So it really has not pre-decided anything, and you should always feel free to tell the court what you think. So that's all I have, and I'll be happy to take questions.
Thank you, Ann. Do you have any questions in the room? I don't have any via Twitter. I just want to remind folks we've got several dozen journalists watching online, so we're going to move on to our next speaker, and we're going to hear now about Michigan's specialty courts, or our problem-solving courts, the drug, mental health, and veterans courts. Our presenter is Dana Graham, who is a management analyst at Trial Court Services. And we'll take a second to get her PowerPoint presentation up, and then we'll hear from Dana Graham.
Hi, good morning, and go green on this day that feels like a holiday here in Michigan, or at least for those of us close to East Lansing. Thank you for having me this morning. I'm going to talk to you a bit about problem-solving courts around the state of Michigan, focusing on drug court, DWI court, mental health court, and veterans court. And before we get rolling, I should mention briefly that our office, the problem-solving courts team within Trial Court Services, also oversees the Swift and Sure Sanctions probation program that Judge Rick spoke about as she runs one of those programs. So Judge Rick kind of covered that. We do oversee that program, but I'm going to focus a little bit more on the problem-solving court treatment courts that we have in our office. So let's see if we can get this to go here. And I do have a brief slideshow, just a few things to kind of guide, and as I understand it, that will be available to everybody on the live stream. And especially we're going to look at some maps in a few minutes here. And so anybody who is having a little bit of trouble seeing the maps, please let us know, because we can certainly make those available to you and get you copies of those. So problem-solving courts are a real departure from the traditional justice system, the traditional criminal justice system. These are specialized programs that address nonviolent offenders who have substance abuse and or mental health disorders, or sometimes both if there's a co-occurring disorder. And they focus on treatment of these offenders and to deal with their underlying issues rather than incarceration, which is sort of where we see the departure from the traditional system. And as such, these programs are often an alternative to jail or to prison. And another way that they're different than the traditional criminal justice system is that they involve a team of professionals. It's sort of a holistic approach in terms of the judges, the attorneys, treatment providers, probation officers, all working together to deal with defendants' underlying issues with the idea of resolving those problems and ultimately those folks enjoying some success as productive citizens. Usually the problem-solving court operates as part of probation, so a defendant would have probation terms that involve problem-solving court requirements, and that supervision is fairly intensive for problem-solving courts. They require participation in treatment and other ancillary services. There's very frequent drug and alcohol testing. There's frequent interaction with both a judge and a probation officer. These folks are coming into court every couple of weeks to meet with the judge and apprise him or her of their progress in the program and sort of see how things are going. So we have a few different types of these programs. The adult drug treatment courts focus on offenders with underlying substance abuse issues. Their crimes are usually linked to that drug issue. Sometimes it's as simple as use and possession charges, people who continue to pick up use and possession charges. Sometimes it's a little bit more indirect. Maybe it's someone who's committing financial crimes in order to get money for drugs, those types of things. So those folks, they'll work on that underlying abuse or dependence addiction issues. There are sobriety and DWI courts. Those deal with drunk driving crimes. Family dependency courts are actually the only type of problem-solving court where we're going to normally see a civil case, and those are civil abuse and neglect cases where the substance abuse is the underlying issue in CPS or DHS involvement. That's Child Protective Services and Department of Health and Human Services involvement. There's juvenile drug courts, which are very similar to the adult model, but deal with juvenile offenders who have some sort of substance abuse issue. We have mental health courts, which follow a very similar model to the drug court, to the traditional problem-solving court model, but the underlying issue there is a severe and persistent mental illness or developmental disability. In mental health courts, we have programs for both adults and juveniles around the state. And then finally, we'll talk about veterans treatment courts, and these are programs for military veterans who have developed mental illness or substance abuse, or sometimes both, generally related to military service. So for example, a PTSD issue or a traumatic brain injury, or perhaps some substance abuse that has developed in response to these traumas, things like that, that has led to an involvement in the criminal justice system. And for those of you who can see the slides, you'll see that we have some quick links on our website that will take you directly to the pages about each of these types of programs with the www in front there, so www.courts.mi.gov/PSC or /drug court, for example. So all of these types of programs generally have the same goals, and that is to reduce recidivism, to reduce substance abuse, to improve the mental health of these participants, enjoy a productive citizenship, and improve quality of life. So regarding reducing of recidivism, right now there's about a 30% reduction in recidivism among drug court participants who are 4 years out of admission, and in mental health court, 3 times less likely to recidivate 2 years after admission into one of these programs. So it's really something it's cutting down not just on people reoffending and recommitting crimes, but that means that there's also then a real cost savings on the back end in terms of not having to prosecute, yet again, somebody who maybe before was someone that the court system might have considered a frequent flyer or someone that they saw very often. These courts are reducing substance abuse. Our statistics show that right now drug court graduates are averaging 354 days of sobriety when they graduate these programs. So they're leaving a program with almost a year sober, which is considerably higher than the national best practice standard, which recommends about 90 days sobriety in order to graduate. So here in Michigan, we're seeing a lot of success with people really getting clean and sober before they graduate. About 50% of drug court graduates have improved their employment status, and this would include felons who are starting without a job and who've been able to obtain a job while they're in the program. And about 95% of mental health court graduates report an improvement in their quality of life while they're in these programs. Again, like I said, all of these goals kind of contribute to another ultimate goal of saving money, saving taxpayer dollars. And right now, the national research shows that for every dollar that's invested in a problem-solving court, the response is about $3 back on investment. Some studies show it's up to $6. More statistics like these, more things in depth, more information about the statewide programs are available in our Problem-Solving Court annual report. It's called Solving Problems, Saving Lives, and that's available on our website, again at www.courts.mi.gov/PSC. Right now, the 2015 report is out there. The 2016 version is due out in the next month or so. I wanted to talk to you a little bit today as well about the locations of the programs, and this is where the maps come in. So if anybody, especially those on the live stream, are having difficulty seeing those, please let us know, and we're happy to share those with you. All total, there's 169 drug DWI, mental health, and veterans treatment courts in Michigan. And right now, as you can see, there's 6 counties that do not have a problem-solving court, but in the next few months, both Delta and Shiawassee are starting drug courts. So we will be down to only 4 counties in the state that don't have some sort of problem-solving court, which means that right now about 97% of Michigan's population has access to a problem-solving court, and that number is rising through new programs starting up and through some regionalization and cross-jurisdictional efforts. The total number of adult drug and DWI programs in Michigan right now is 86. And this includes regional DWI programs, which are programs that have their home base in one court, but through cross-jurisdictional agreements are able to accept cases from neighboring counties or neighboring jurisdictions without having to completely transfer the case or change venue or do anything like that. These are agreements that are set up ahead of time to share these resources. And for Michigan to develop those regional DWI courts, they're actually the first of their kind in the country, and other states are now looking at that model. It's particularly effective in rural areas. You can see on the maps, kind of the top row is where we have our adult circuit drug courts, adult district drug courts, and DWI courts. The green map is family dependency treatment courts, and we have 13 of those in Michigan. Those are generally at the circuit court level in that they deal with family cases. Juvenile drug courts also at the circuit level in the family division. We have 15 of those in Michigan. That's the orange map. Mental health courts, and hopefully this one's a little bit easier to see because there's just the one type of those. Mental health courts, we currently have 28 in Michigan. We do have a couple of regional mental health courts as well that followed that regional model that started up with the DWI programs. And mental health courts serve both juvenile and adults, depending on how that particular program is set up. Veterans treatment courts, we currently have 23 in Michigan, and there are also 3 drug courts that have a track specifically for veterans as well. So the veterans treatment courts is 23, and we anticipate that a few new veterans treatment courts will be starting in the next year or so as well. So moving forward, there's a few things kind of to consider and a few things for journalists to keep in mind. The first that I do want to talk about just real briefly is that the governor's budget this year does call for increased funding for problem-solving courts. We're anticipating the opportunity to potentially allow for the use of medication-assisted treatment in these programs. We're anticipating an expansion of veterans treatment courts with a little bit of increased funding that will allow us to offer more veterans treatment courts, additional programming for the veterans in those programs, and also the courts themselves will be able to take more participants, as most of our problem-solving courts do have a cap on the number of participants they're able to handle because the work is more intensive than a traditional probation caseload. And then the increased funding from the governor's budget also calls for expansion of drug courts. Again, the ability to start more programs, accept more participants, and offer more services within those programs as well. In terms of specifics for journalists, the courts tend to be very, very proud of these programs. They're something that is a real feel-good story for the community. They're positives that are going on in the court. Again, they are a departure from the traditional criminal justice system, so it's something that the courts tend to be really proud of and want to be able to share that success, particularly through the media. So it may be something in these situations where the court is actually reaching out to you, is letting you know that there's going to be an upcoming graduation or that the judge is going to be speaking to a particular topic, or that perhaps the new program is starting up and they want to get some information out to the constituents, out to the public about that particular program. So this is an area where we tend to see fairly frequent interaction between the courts and the media in terms of publicizing these programs. One thing to keep in mind, though, with that publication or publicizing of these programs is that the participants who successfully complete these programs often have a graduation ceremony. It's a small ceremony where they're able to have their friends and family come, where perhaps they give a speech. They're congratulated for completing the terms of this program. And those graduations will often be open to the media because these graduates are real-world success stories to show how these programs are really making a difference in impacting these communities. But one thing that's really important, particularly with the graduates or particularly if the court is open to the media, is participant confidentiality. The courts are going to have to follow some federal regulations, some things like HIPAA and the Code of Federal Regulations in terms of protecting participant confidentiality. So sometimes the individual cases are non-public due to the legal status of that particular case. And then sometimes it's just a matter of protecting health information or substance abuse information. So those are things that the media will want to be aware of, and that certainly the courts are going to work very hard to make sure that they're not disclosing things that aren't supposed to be disclosed. Sometimes a particular graduate may not be comfortable with their story being shared with the media. The courts will generally be aware of that and will work with all of you on those issues. So it's just something to be conscientious of. And then another tenet of problem-solving courts is that they should be evaluated. The national organizations will tell you these programs should be evaluated. We should be looking at outcomes. We should be looking at performance. And so the evaluation of these programs and sometimes the reports on those evaluations are often another thing that's shared with the media to publicize those successes, to share how things are going in those particular programs. So that may just be something that you would want to keep an eye out for in terms of what the court may be reaching out to you with. And then our performance and outcomes report, which of course is a nice lead-in from the individual local trial courts talking about the evaluation and outcomes of their programs, is on the statewide level. Our office puts together, as I mentioned, that Solving Problems, Saving Lives report that comes out every year. Again, it's available on our website, www.courts.mi.gov/PSC. It's got detailed information on the programs, the statistics, program outcomes, commentary from judges, commentary from program graduates, as a matter of fact. So there are some stories in there, things like that, that would probably be really useful to a journalist in terms of being able to get some insight into these programs and some more detail than what I was able to cover here today. So I would encourage everybody to check out the report. The 2015 version is out there now, and we anticipate that the new one will be published in the next year. And if there are any questions, or as you move on working on these programs, working with the courts about these programs, please feel free to contact us either in my office or through John's office at the Public Information Office. So if there are any questions, I'm happy to answer them. Otherwise, thank you so much for your time.
Thank you very much, Dana. Was there a question in the audience? Okay. Terrific. Thank you very much. And now we're going to talk a little bit about something that's really, really important to the Supreme Court, and that's keeping track of judicial performance and making sure that our justice system is serving the public and being the best possible steward of resources. So talking about our dashboards and judicial performance is Stacy Westra. management analyst with our trial court services.
Bear with me a moment while I get the presentation together here. As John said, I'm Stacy Westra, and I am the Circuit Court Analyst for the Trial Court Services here at the Supreme Court. I also specialize in County Clerk's constitutional relationship as the Clerk of the Court in the Circuit Court. So that is kind of what I do here for a living. What I'm presenting on today are performance measures, and I'm happy to do it. It's something that's near and dear to Trial Court Services' heart, and we've worked on a great deal of time in helping the trial courts manage the business that they do. So what we're going to talk about today is why we use performance measures, what information you as reporters can find there, and why they are important. And as you might guess, along with everything else, it's on our website. So let's look at why we use performance measures in the court. Certainly we use them to improve customer service. They're also a management tool, and they're actually a series of tools that help administrators effectively manage the business of the court. They're a catalyst for change. Change for change's sake never usually results in anything positive for anyone. It's great to base any change that you make on data, and that's what performance measures do. And they're also effective means to recognize issues and inform the public about the business of the courts. Many times people think of the courts and judges as this very mysterious thing. This kind of demystifies that process because we really are in the business of providing justice to our customers. So where is the Judiciary Dashboard located? It's at this extraordinarily long website address. And I'll give you a shortcut to this in just a moment. But let's talk about the sections of the dashboard that are out there with information for you. We'll talk about timeliness as a performance measure, efficiency of the court. We'll also talk about technology, but perhaps not in the way you might think. We're speaking of adoption rates of new technology when we're talking about this topic. Performance, which is court metrics and evidence-based practices. And then access, which is connecting the courts to the public and to you as reporters. Now that shortcut that I was talking to you about, if you actually go to the www.courts.mi.gov website, there's a search field that appears in the right-hand upper corner of that website landing page. Type in Judiciary Dashboard, and then click on the link that shows, and you'll land on this landing page, which is our Judiciary Dashboard. Now this particular screenshot is of the timeliness section of the dashboard, and you'll see two arrows. The blue arrow, which is the section header, which in this case is timeliness, and then the red arrow, which points to why it matters. Why it matters is important is because this provides an explanation of whatever section you're in. In this particular situation, we're looking at clearance rates. And if you clicked on why it matters, you would land at this explanation of what that is. Clearance rates are a percentage calculated as the number of cases coming into a court compared to the number of cases being disposed or closed. So if you're looking at a percentage rate over 100%, it means that the courts are disposing of more cases than are being filed. Under 100% means that they are filing more cases than are being disposed. So as you look at the next slide, we're looking at clearance rates identified, and in the black arrow, the trial courts in 2014 had a clearance rate of 100%. Means that this is an equal number of cases coming in to be filed that are being disposed for the year of 2014. Any discrepancy above or below 100% helps us as trial court analysts identify backlogs or disposition issues within the trial court. And courts know these numbers and watch these numbers very closely. For case age rates, which is located in the bottom section of this at the red arrow, we're looking at case age rates. This is a percentage of cases resolved within a suggested time. The Supreme Court has guidelines for each case type, and they vary depending on those case types. So unlike clearance rates, case age rates will never be above 100%, or will never be at 100%. It's not possible. There's a variety of circumstances that occur in every case that would keep things for longer than intended. So here you'll see that the trial courts in 2014 have disposed of 96% of their cases within the guidelines established by the Supreme Court, which is pretty good considering the number of cases that come through. So under the next category of efficiency, which we talked in our bulleted items, there are really too many things to include, but I will give you 4 examples of what we're talking about when we talk about efficiency in general. You might have heard one of the judges speak about the Judicial Resources Report. Over and underjudged courts are important to us, and the State Court Administrative Office assesses each court's judicial need and recommends adding or eliminating judgeships in specific courts. In 2011 and in 2013, extensive reductions were made to right-size the judiciary, and the progress is posted on what courts have the right number of judges. Also, the annual savings due to those reduced judgeships are posted as well. By sharing judicial resources, cases can be handled more efficiently. Concurrent jurisdiction plans is another term you heard today. They allow circuit, district, and probate judges in the same circuit to assist each other with cases. We post that progress on the number of courts and their number of concurrent jurisdiction plans. Courts used to also have their own chief judge. We now work with courts who have one chief judge over multiple courts, and you'll find those numbers in the percentage of courts posted on the website as well. So we talked about technology and the adoption of that technology, and we post the data as adoption and usage rates. So each arrow represents a separate data category, and at the blue arrow, we're talking about adoption of e-filing. Now, our statistics indicate that we only have 8 courts piloting e-filing at this time, but the interesting fact about that is 40% of the population in the state is served by those e-filing pilots. At the red arrow, we're talking about courts that currently have adopted and use the state's case management system. And at the black arrow, we're talking about the judicial data warehouse utilization. So we're talking about things like the number of agencies that access the judicial data warehouse, the number of courts contributing their information to that warehouse, the number of inquiries made, and the number of court records in that warehouse. And as of 2014, 46 million records are currently in that warehouse. So a few more elements of technology information that are posted to the website that you might find when you go there are courts that have video equipment in their courtroom. Did you know that every county in the state has a video conferencing equipment set up in at least one, if not all, of their courtrooms? And that fact has saved the Michigan Department of Corrections, as of 2014, $2.8 million. Another item is online payment technology. Did you know that as of 2014, 95 district courts accept online traffic payments? Well, that might not sound like a lot of courts considering the numbers that you've heard today, but that provides 85% of our population access to online traffic payments here in our state. So the next category is court metrics and evidence-based practice. We post information about public satisfaction in the trial courts, and surveys reveal things like if customers felt they were treated with respect when they were at the courthouse, if they believed their cases were handled fairly. And in addition to that, we not only survey our trial courts for that information, the SCAO itself in trial court services posts the results of their own customer satisfaction survey, so we're not immune to our own performance measures. Additional metrics are tracked are court compliance with collection programs, statewide child support paid in the month it's due, and problem-solving court recidivism data. So the final category is connecting the courts and the public. The information posted here demonstrates how we are working to do this, and a variety of colored arrows here point to the tracked information. So we look at our own metrics for our own website as website sessions engaged in and pages viewed at the blue arrow. The red arrow, language access, is another way to access courts. Not every litigant that comes into court speaks English. So we track language access and the number of certified and qualified interpreters in the state and the total number of languages provided by those certified and qualified interpreters. At the green arrow, we even provide information about community dispute resolution case disposition numbers and overall settlement rates for these centers. So here's the landing page for trial court performance measures themselves and the work that the committee does. You can look at the blue arrow, and there's an area where it actually lists the members who are on that trial court performance measures committee. Judges like Judge Sullivan in Kent County and other judges come together to look at these performance measures and make sure that they're appropriate for the courts and help in the rollout, literally, of these things going out to the courts. Implementation plans can be found here, important memos about performance measures going out to the trial courts, and then links to individual courts, so you can look at an individual county's court information, drill it right down to their district court level if you would like. So to see the individual court data, you'll see a page like this. And the red arrow shows you the media releases on performance measures. There's a section for that. And then you'll see the state over on the left-hand side of the page where the blue arrow is. Here is where you could actually click through. You'll get a county map, and they will discuss all of the performance measures from case to age disposition rates all the way down to juror utilization for each individual county. And when you click on that individual county, you'll land on a page like this. So in this particular page, it shows Ingham County. And for Ingham County, the way that it's broken down is it's by the performance measure itself, and then each court's information is underneath it. So you can click and drill down to that individual court's information. And you'll see headers for the public satisfaction survey, timeliness, so we're talking about case age rates, clearance rates here, recidivism data related to them if they have a problem-solving court, and all of the associated performance measures that are currently rolled out in that court. So that's a ton of information to try to get through, and that's just a portion of what's out there and available to you. What I would encourage is that anyone looking for this information, go out to the website, click on the various links to look at all the information that's out there. I would also encourage you that if you have any questions after you've done that, please contact John Nevin in our office. He is more than willing to assist you in finding out information or answering those questions. And also, we want to make sure that we are available to you as well. John has a great deal of staff in trial court services available to him as well. So if there is a burning question that you need an answer to out there, we are happy to provide that for you. So that's trial court performance measures, and I'm happy to take questions at this time.
Terrific. Thank you very much, Stacy. Now, as we move on with the Law School for Journalists from the Michigan Supreme Court courtroom, our next speaker is going to talk about the anatomy of a criminal case, what you need to know about criminal procedure. And we are very fortunate today to have with us Bill Vailliencourt, the Livingston County Prosecutor. Bill.
Thanks, John. I'm going to talk about the anatomy of a criminal case. We're going to cover it all in 15 minutes. Primarily, I want to direct you to two resources. On the court's website is a journalist's guide to covering Michigan courts. It was updated in 2014. It's a very thorough guide, detailed guide that I would ask or direct everyone to take a look at that. That will probably answer a lot of questions. There's a huge section in there, on all the legal glossary and the terms that are used in the courts. And then there's a short 2-page mini summary of the process that's also been provided for this. Both of those summarize the nuts and bolts as to how the criminal process works. And I think our district judge and circuit judge earlier this morning gave a pretty good description as to how that process works. So I want to spend most of my time talking about what probably interests you most, what a prosecutor can talk about, what they can't talk about, and why. And I'm going to start with the charging process, because that oftentimes can seem very mysterious, because it doesn't happen in court. It happens behind the scenes in the prosecutor's office. The process starts with the prosecutor reviewing everything submitted by police. That's going to include, police reports. In some cases that may be a 3 or 4 page report. In some cases it may be hundreds or even thousands of pages. Going to review witness statements, videos if a witness statement is recorded, physical evidence. We'll go through all of that material, and we may be able to make a decision based on that, or we may need further investigations. We may ask the police to conduct additional witness interviews. We may ask them to execute search warrants to search for additional evidence, obtain records. We may even want to do investigative subpoenas, which is a process where we can subpoena somebody to come in and have them testify under oath and describe what they've seen. They're just like depositions. So all that obviously can take time. And depending on the nature of the case, it may be reviewed by multiple prosecutors to get different perspectives on the evidence and the nature of the evidence. And if there's scientific evidence, there may be even more to review. If it's something that's newer type scientific evidence, we'll need to investigate, how reliable is it and is it admissible? So obviously, this process can be time consuming. There's no deadline or easy way to predict how long it's going to take. The objective is, we want to get it right and we want to go through it before we charge rather than discover issues afterwards. One thing to remember is that the standard to charge someone with a crime is different from the standard to make an arrest. To make an arrest, probable cause is required based only on the information known to the police. That could be something as simple as just a statement from the victim or even just a statement by the defendant admitting to a crime. That could provide probable cause to make an arrest. But that may only be part of the story. The standard for a prosecutor charge is different and it's higher. The evidence needs to be admissible and it needs to be sufficient that we can prove to a jury beyond a reasonable doubt that a crime was committed and that the defendant committed the crime. And oftentimes the difference between these two standards is the difference between knowing something and proving something. We may review an investigation and a defendant's background and firmly believe that the defendant is guilty, but it may be based on inadmissible evidence, such as looking at what their prior record or prior convictions are, or information from a co-defendant that's not going to be admissible. So our focus needs to be on determining what is admissible and whether it's sufficient to prove guilt beyond a reasonable doubt. One longtime prosecutor once said, and I think it's really accurate, is that the reviewing prosecutor is really the defendant's first lawyer, because we're not only reviewing the legal sufficiency of the evidence, we're looking at whether it's admissible, whether it's going to be subject to suppression, privilege, or any other bar. Basically, we're looking to see that the evidence is enough that actually can prove guilt beyond a reasonable doubt. And what's probably going to be most frustrating to you as journalists is that during this process, we're not going to be talking. The most we're probably going to be saying is, we're reviewing it, we'll let you know when we have a decision. We're not going to be getting into the details of what's going on because we want the investigation to proceed. If we end up denying charges, we're not really going to be making detailed comments about the case either, because we don't want to unfairly disparage a defendant by saying something, well, we think they're guilty, but we just can't prove it. That's unfair to the defendant. We don't want to unfairly disparage victims. So you're not going to get a lot out of us in the warrant stage. Once charges are filed, prosecutors, like all lawyers in the system, are bound by the Michigan rules of professional conduct. And there is a specific rule governing trial publicity, and there is a handout with the relevant parts of those rules that's available. And this is going to be the source of the conflict between your wanting to get the full story and what the police, the prosecutors, and defense attorneys are able to tell you. And the primary reason for these ethical rules is a concern that a defendant has the right to a fair trial, meaning that jurors decide the case based on the evidence that they hear in court, not what they read in the paper. And I'll understand you're trying to get it right, but the nature of the beast is that the information that you're given either might not be complete, it's obviously not subject to cross-examination or challenge, and so it's unfair that a defendant be charged with a crime, have a jury that's thinking about, well, I read in the paper about confessions and all those things, so I know he's guilty. And then things may happen differently in the trial and evidence ends up not being admitted, not being admissible. And so the focus for everyone involved in the system is to ensure that the defendant has the right to a fair trial and actually has a fair trial. And if you look at the ethics rule, it's a pretty lengthy laundry list of things that you can't say. or that we can't tell you. And unfortunately, that's a lot of what you really want to know. You look at the list. Character, credibility, criminal record of a defendant, or the identity of a witness or their expected testimony. So we're not going to be able to tell you about the particular background of a criminal defendant, or what a specific witness is, or what we think they're going to testify to, because obviously, we may think we know what the witness is going to say, but when they actually come to court, that can change. Yet to the extent it may have been disseminated, what we thought was going to be said, that can taint the process of finding a fair jury. The possibility of a plea. We're often getting a question, well, are there plea offers made? Is something going to happen on this? Well, if we start saying, well, yeah, we think there's going to be a plea, well, what happens if there isn't? Well, now you've reported and the jurors have all read that, well, the defendant was considering pleading guilty. The concern is obviously the impact that has on their right to a fair trial. We're not allowed to comment about the existence or contents of any kind of a confession, statement, or admission, or that the defendant refused to make a statement. Again, because what if the evidence is suppressed, the statement is suppressed, and we're all familiar with the idea that a defendant's silence is not to be used against them. If we get up and start saying, well, the defendant had his opportunity to talk and he didn't tell us, that's what's going to be conveyed to the citizens who make up the jury pool. And so again, the concern is that it may taint the right to have a fair trial. We're not allowed to talk about the results of specific examinations or tests, or the identity or nature of physical evidence to be presented. So, in drunk driving cases, generally that means we're not going to be telling you precisely what the test results were, or what certain DNA results were, or you're most definitely not going to be hearing about polygraph results. Those are absolutely inadmissible and are considered confidential under state law. So you're not going to be getting a lot of information about that. We're not allowed to give an opinion as to the guilt or innocence of a defendant. If you ask a prosecutor, obviously our opinion is going to be the person we've charged is guilty. That's, we don't charge people that we think are innocent. We only charge people that we're convinced the evidence is sufficient to prove beyond a reasonable doubt. So that's an answer you'd automatically get from a prosecutor, but also think about a defense attorney, how that would put them in an unfair position. They may know that their client is actually guilty. Maybe there's technical defenses they want to offer, but if the attorney is then placed in a position where he's got to offer an opinion, that puts them in an inappropriate position, and also, again, affects what could happen if there ends up being a trial. And then there's kind of a couple of catch-alls that any information that a lawyer knows is inadmissible and might create a risk of prejudicing a fair trial. So, this is the catch-all that, anything that's not covered in the other laundry list, if it could have an impact on whether or not a defendant receives a fair trial, we're not allowed to talk about it. And then finally, the rule says that, we're not allowed to even tell you that a defendant's been charged with a crime, but there's a big exception that swallows up the rules, unless it's accompanied by a statement that the charge is merely an accusation and that the defendant is presumed innocent until proven guilty. So that's why when we do release information saying we've charged defendant A, B, and C with these crimes, it's always going to have a statement at the end saying these are merely accusations. It's going to be up to the trial process to determine whether a defendant is innocent or guilty. Now these are rules that apply to all lawyers, prosecutors, defense lawyers, but there's also a provision in the ethics rules that says prosecutors are supposed to make sure that police abide by these rules as well. Now, we don't govern what the police do or control what they do, but we try to encourage them to follow these same rules for the same reason, because if they're putting out this kind of information that could affect a fair trial, it doesn't matter whether it's coming from us or from the police or anyone else. Judges, as somebody mentioned earlier, they're not going to be commenting at all. It's not even worth calling them to ask, because they will not make any comment whatsoever about a pending case. Now, the rule does tell what we can say. We can give you, the nature of the claim or the offense. So we're going to be able to tell you, that we've charged so-and-so with a crime, the murder, who the victim is, where the body was located, those kind of things. But it's going to be pretty generic, generally. We're not going to give you a lot of detail, keeping in mind all the laundry list of prohibitions. Now, we can talk about information that's contained in the public record. And sometimes this information actually can be quite broad. Normally, we can't talk about prior record, but oftentimes if a defendant is charged as a habitual offender, on the complaint or the information is going to be the list of the defendant's prior convictions that we're charging. That's a matter of public record, so that's something that can be, that can be told. So it oftentimes will be said when a defendant is charged that, he may be charged with this crime, but because he's a habitual offender, he's looking at an enhanced status. Frankly, there are some tools out there for you to be able to find out prior records of defendants or witnesses or anybody, regardless of what the charging document might say. Two very easy sources. First is the Department of Corrections website has OTIS, offender tracking. You can punch in offender's name, and if they're currently on parole or probation, that information is going to be in there, and oftentimes it will have their prior conviction information. You can also go through via the Michigan State Police. On their website, they have information about a service called iChat, which allows you or any member of the public to get a list of an individual's public convictions. There is a fee associated with that, but it's something that's available. So, but again, we can talk about information contained on the public record. So, the prohibition says we don't talk about plea offers. Well, if we were just in court, and sometimes it's frequently put on the record whether or not there have been plea offers, well, then obviously that's a matter on the public record. So things that are on the prohibited list can still come in. One example is at an arraignment, when the question of bond is coming up, there may be a more detailed discussion of the facts of the case. There may be statements about a defendant's confession or prior record in order to show the magistrate either that the proofs are strong and so bond should be high, or that there's a risk of flight. Those are matters that are going to be on the public record, so there's things that can be discussed. We can tell you if an investigation is in progress. We can tell you scheduling, if there's a court hearing coming up, we can tell you, yeah, there's a court hearing scheduled next week. It's scheduled on the defendant's motion to suppress the defendant's statement. That's in the public record. It's a scheduling. We can tell you afterwards the court made a decision and granted the motion or denied the motion. We can also give information if we need assistance in obtaining evidence. So if we're looking for other victims, we can give out enough information so that the public understands that we're investigating so-and-so and we're looking for additional information there. If there's somebody that, evidence, we can give a warning of danger concerning the behavior of a person. So if there's somebody out there that we think poses a threat to the public, we're allowed to release that kind of information. We're allowed to release, the identity, of a defendant, residence, occupation, family status, that the defendant's been arrested, when and where he's been arrested, and by whom, and the police agencies that have been involved in the investigation. And as far as public comment from prosecutors, every county is going to have different rules depending on what their elected prosecutor, what their position is going to be. Generally, so they'll identify who can talk to the press. Generally, most assistants, are not going to be talking to the press. It's usually going to be the prosecutor, chief assistant, or maybe somebody else that's been designated to answer questions. So that is, in a nutshell, a criminal process and what lawyers and prosecutors can tell you and what we can't. Super, any questions?
Thank you very much. Yes, we do have a question that came via Twitter. Wants to know, how do you weigh the public interest with due process in releasing certain information related to an investigation?
Well, I mean, that's where the rules go to, they give us the list of things that we can consider. Obviously, we want the public to have confidence in the system and what's going on, and that, if charges are denied or being reviewed, that we're looking at a number of different things. So it's a balance, but ultimately, we have to ensure that the defendant enjoys the right to a fair trial. And so, that means that when you want information, until the case is over, we're not going to be able to give that information, because we don't want to have situations where either, there ends up being problems with trying the case, it has to be tried in a different jurisdiction because of pervasive publicity, So that's the balance, but we have to err on the side of making sure we're protecting the defendant's right to a fair trial.
We have a,
What's the protocol when it's one of your own?
I'm sorry?
What's the protocol when it is one of your own?
Same rules apply, whether, it's whoever is charged, the concern is you want to protect their rights to have a fair trial.
The Ingham County prosecutor, then what happened?
And I'm not going to comment on pending cases for all of these reasons.
Does that go to another jurisdiction?
Oh, well, generally, there is a procedure in place for if a prosecutor thinks that there's a conflict of interest. So for example, if there was an investigation that involved, one of my friends or one of my employees or something, there's a process in place where I can go to the Attorney General and say, I have a conflict of interest, so I want a different prosecutor to handle that case. The Attorney General will designate that individual, and then they'll handle the case from beginning to end that way. And, that's a process that, every prosecutor has and can take advantage of.
Well, it would be the Attorney General's office.
Yes, in that case, yes, it's the Attorney General, so they will handle the entire case. It won't be handled by any other office.
Is there any instance where something like, just using a hypothetical, would have to go, well, there's only so many prosecuting attorneys, I assume you have an organization that you can be no one another. So, again, is there a potential conflict there where you have to bring in somebody from other states?
Well, I'm not aware of that ever happening. Usually, the process for designating a special prosecutor, the practice is generally it's another prosecutor, elected prosecutor, or Attorney General. But I think under the statute, it doesn't necessarily have to be. So if the Attorney General wanted to designate a private attorney, I think under the statute that's permissible. But I'm not familiar with that happening too often. Generally, other prosecutors handle cases for adjacent counties and handle those kind of cases.
Well, that's what we're all familiar with.
okay. Super, thank you
All right,
very much.
thank you.
Thank you, Bill. Now, our next speaker this morning is going to address, I think, one of the bodies, I think, in the Michigan state government that's probably the least well known, and that's the Attorney Grievance Commission. And we're very lucky with us this morning to have the AGC Administrator, Alan Gershel. Alan?
Good morning. Thank you. Good morning, everyone. Good morning, everybody out there in Etherland. Again, my name is Alan Gershel. I'm the Grievance Administrator for the Attorney Grievance Commission. I provided you with a sort of flow chart. I hope you find that a little bit helpful. I don't have a lot of time, so what I thought I would do is give you an overview of the Michigan Attorney Discipline System, and hopefully you'll have some time for questions. Okay, the Grievance Commission is by definition, is the prosecution arm of the Michigan Supreme Court. It's our responsibility to investigate and prosecute attorneys who violate the rules of professional responsibility. The Grievance Commission itself consists of 9 individuals, 7 lawyers, 2 lay people, and they're appointed by the court. In terms of what we do in the Grievance Commission, we review the complaints about lawyers that come in. On the average, we get, I think last year, about 2,800 complaints a year, and they come from everywhere. Unhappy clients, from members of the public, from judges. Really, anyone has standing, so to speak, to file a complaint with us. And again, mostly they come from clients, but we get them from sometimes opposing counsel in cases, from judges, and for example, if we see something in the newspaper that we think has a potential for a violation of the rules, we can issue an investigation in my name, and we can, and that happens with some frequency. Okay, when a request for investigation comes in, there are certain requirements. It must be in writing. It must name an attorney. A complaint cannot be brought against a law firm. We don't have jurisdiction over sitting judges. That's handled by the Judicial Tenure Commission. It must be signed by the complainant, and it must describe the alleged conduct. Once that comes in, it's reviewed by a senior attorney in my office in our intake unit, and it's reviewed both for compliance with the form requirements, but also we look at these closely. You know, sometimes they come in for people who may have some difficulty communicating, and so we really do our very best to look at the content of the complaint. If we think we need more information, we'll ask the complainant to give us more information. When we have that in front of us, if we think that on its face it simply doesn't present a case that would violate the rules, I have the authority to close out the case. If we think that the case does have some merit, we will require the attorney to answer the request for investigation. That must be done within 21 days. Again, it must be in writing. When that comes back in, it's again reviewed in the intake section. At that point in time, if the answer is sufficient and we believe there has been no merit to the case, we can dismiss the case at that point. If we think the case does have some merit, it then gets assigned out to one of the staff attorneys in my office. If the file is closed in our intake, we notify the complainant, and if there has been an answer to their complaint, we enclose the answer from the lawyer to the complainant as well, so they know what the response to their complaint has been. If they're unhappy with that result, they can ask for reconsideration, and sometimes they'll present us with additional facts, which will allow us to continue looking at the case. If the case does have some merit, it's then assigned out, and the Grievance Commission does have some pretty potent investigative powers. We have subpoena power. And, for example, we can subpoena documents, and unlike in a criminal case, and this may surprise the prosecutor here, we can actually require the attorney to come in and give us a sworn statement. And he must comply, or she must comply. And the only reason not to would be if, in fact, there's a concern about a privilege issue. Like if there's an ongoing criminal case, for example, and they can't provide a statement, then we won't insist on that. But fairly often, we make the attorney come in and give us a sworn statement. So we do have subpoena power. We can take statements from witnesses, and if an individual fails to comply, we can seek contempt for their noncompliance. All right, so the investigation goes on, it continues, we come to a completion. There is some belief that some sort of discipline perhaps may be appropriate. At that point in time, the case is, after it's reviewed by me, it'll be submitted to the Grievance Commission. They meet once a month, and they'll review the cases that we prepare for them. And their range of disposition can run anywhere from asking us to do more work on the case, to agree with us to close the case. We might make a recommendation for what's called contractual probation, and a situation like that might be if an attorney has had some substance abuse issues, and rather than formal discipline, we'll close the case, call contractual probation, and ask the attorney, require the attorney to engage in some kind of treatment plan to try and deal with the issue. We can also, moving up sort of the ladder of discipline, we can seek what's called an admonishment, which is non-public discipline. Public's not made aware of that, but again, if there's continued misconduct, that prior admonishment can be used to enhance the penalty, sort of like a prior conviction in terms of a criminal case. If the conduct is serious enough, we will request the Commission for authorization to file what's called a formal complaint. That's the official charging document in our system. The prosecution talks in terms of an information, that's their charging document. For us, it's called a formal complaint. At that point in time, the complaint gets filed with the Attorney Discipline Board. Michigan is a bifurcated system. By that I mean we're the prosecution arm, and the Discipline Board is a separate entity, and they're sort of the adjudicative arm, or the judges in the system. And once we file that complaint, then that becomes a matter of public record. And the next steps in the process can range anywhere from what we call a consent discipline, which by analogy would be a guilty plea, for example, in a criminal case, or we go to a hearing on this matter. Again, it's a public hearing, and they're tried by panels all over the state. And if we satisfy our burden, which in a discipline system, unlike a criminal case, is by a preponderance of the evidence, at that point in time, and the first part of this case is called the misconduct phase. If we prove our case at that point in time, we then move into what's called the penalty phase, or the discipline phase of the case. Discipline can range everywhere, anywhere from finding of misconduct, but no discipline, which is unusual. The next level would be a reprimand, a public reprimand. The next step up would be a suspension. A suspension of a lawyer must be for at least 30 days. A suspension that is up to 179 days means that if the lawyer is suspended for that length of time, which means they must shut down their practice, they must notify their clients, but at the end of that period, they're eligible for automatic reinstatement, assuming there's been no problems along the way. If the suspension is between over 180 days, they must go through a formal process for reinstatement. And the burden is high. They must go in front of a panel, in front of the discipline board, and establish by clear and convincing evidence, which is a pretty high threshold, that they're now eligible to re-engage in the practice of law. A suspension for over 3 years means that the attorney may have to actually go through the recertification process, which could mean taking the bar exam, and for many lawyers who've been out a long time, they're done. You know, once was enough. They're not going to do that again. If it's over that, you can be disbarred, but there's no permanent disbarment in Michigan. You cannot seek reinstatement for at least 5 years after you're disbarred. There is an appellate process, which is interesting. Unlike a criminal case, which you may be familiar with, 3 different entities can appeal a discipline case. We can, the Grievance Commission, the respondent attorney, and the complainant. So the person who brought the case, if they're not happy with the result here, they too can seek review. The review is done in front of the discipline board. Also 9 individuals, 7 attorneys and 2 lay people, who are the appellate process, the appellate court in the discipline system. And typically that will be the final step, although you can seek leave to appeal here in the Michigan Supreme Court, but that doesn't happen very often. So I've given you a quick tour, about as quick as I can, through the discipline system. So happy to take any questions if anybody has any.
Yes, we do have a question that was submitted online, and I think you addressed this as you described the discipline system, but maybe if you could just clarify for this reporter who's asking, how would they find out information about lawyers who are under investigation, and kind of make it clear during the process when that information is available?
Unfortunately, they can't. Is the short answer to that question. Much like a criminal investigation, there are very, very strict non-disclosure rules imposed upon on my office for reasons that make sense. When someone's under investigation, that shouldn't come to light until there's been any kind of finding. They're entitled to that sort of presumption also. And I do get calls from the media, and unfortunately I have to say, I can't even tell you if a complaint has been received by the office. And I know that may be frustrating because in the paper it says, I'm referring this matter to the Attorney Grievance Commission, and I'm telling you I can't comment on it, because I can't. I'm absolutely precluded from doing so. But once the matter, if in fact there has been approval for a formal complaint, we've begun posting our complaints on our webpage. We sort of redesigned our webpage, and I would encourage you to look there. It's got a lot of helpful links for you. And also you can look, the Attorney Discipline Board has its own webpage, and you can actually search by lawyer. It's a very good webpage in terms of prior discipline matters that have become public. So those are two vehicles to look to.
We have a couple more questions that have come in via Twitter. Does the AGC consider or weigh ineffective assistance of counsel claims made in the Court of Appeals?
We do get some of those cases. We have gotten cases where a court has found an appellate court ineffective assistance of counsel. And for those of you that follow the criminal process that all know that that's a really high threshold for a defendant to satisfy. So when we see that, that's a serious issue for us, And the short answer is yes. If we see that, we see a Court of Appeals opinion that's found that, we will require the respondent to file an answer. And so, yeah, those matters are investigated by us.
We do have another question via Twitter. Approximately what percentage of grievances filed result in an official complaint made by the AGC and then also result in disciplinary action?
Okay, again, I urge you to look at our webpage. I've put the annual report up for 2014. I'm about to put the annual report up for 2015. But to answer that question, we had in 2014 135 formal complaints filed. We'll be up a little bit this year. And back to the previous question, most of the complaints we get have to do with criminal law issues. That's by far and away the biggest category of case we get. We had about 135 formal complaints in 2014. I explained to you the admonishment process. We had about 137 admonishments in 2014 as well. But again, in the next week or so, I hope to have our new annual report up on the webpage.
Thank you very much for your presentation.
Thank you.
So as we move on with the Law School for Journalists, our next speaker is currently a lawyer and a former journalist. So he's been on, I guess, both sides of the aisle or both sides of the microphone. Giving us some practical tips for covering the courts. We're very pleased to have with us Mike Nichols.
Thank you, John. Good afternoon, good morning, right on the precipice between morning and afternoon. How is everybody? Everybody out there online. I want to first say that before I became a lawyer, one of the proudest days of my life, May 11th, 1999, I was a broadcast journalist for 10 years and put myself through undergraduate school and law school. The last 3.5 years, I was a broadcast journalist. I was also a law student, and I thought I knew more than I really did during that phase of my career. Are you putting up my PowerPoint? Thank you. That's okay. I've got just a couple of tips for you, and I was told I'm supposed to fill 15 minutes. Hopefully you have questions or will have questions. I think Justice Young will give me time when it's time to... I'm not the timekeeper here. Okay, and left click to move. There we go. One thing I learned both when I was a reporter and becoming a lawyer is, you really have to get over that fear. You're going to have it. I still get it every time I stand up in front of a jury or a judge. Moments like this, you get sweaty. You just have to get past it and do what you got to do for your client, but also a little healthy respect for our system and our process. That's me, by the way, although you already know that. So lawyers can be scary people and intimidating people. Judges can be as well. But the first rule I have is there's no such thing as a bad question unless you don't ask it. I can tell you that we as lawyers, and I'm guessing the same as holds true for prosecutors, when things get really messed up from a factual standpoint, covering our cases, sometimes we're a little cranky the next time we get a phone call from you. And it's nothing personal, it's just we sell our time. That's our stock in trade. And there's only so much time in a day. And when you've got to go through, say, thousands of documents for a particular case, you got to set aside time working on those documents for your client or your case if you're prosecuting the case. And when you get a call from a reporter, it's really important to take it and respond to it, but you just got to get in that frame of mind to deal with the reporter. And it can be hard if, here's an example. Last week in a certain case that I'm handling, my associate attorney the other night said, "Hey, did you see this on the news? They got that wrong, and they got that wrong, and they got that wrong, and they got that wrong." And I just thought, man, I tried so hard to explain to the reporter the particular rule of evidence that we were utilizing and arguing, and it was a very narrow thing that I thought was important and not that difficult to get right. But I also understand court is very, very boring because I've been on your side of the equation. unless it's a salacious kind of case where they're talking about people getting beat up or, sex, or maybe the defendant or somebody is jumping across the bench at the judge, it's really not that interesting, right? And I understand that. But ask the question, and if you don't get a straight answer from the lawyer, ask a follow-up, get clarity. I never have a problem with it, even if I'm trying to obfuscate, which I usually don't do, unless it's trying to give you a no comment without giving you a no comment. But follow up and say, okay, what does that mean when you're saying if a person makes a statement in furtherance of plea negotiations, what does that mean that you're trying to keep this particular statement A, B, and C from coming into the case to be used against your client? Tell me more about that. Why is that important? It's okay to ask that question, and if I tell you the straight answer, it's probably going to be that strategy, and that's between my client and I, and you'll find out in the courtroom. Please don't take offense. I said that to a reporter the other day, and he looked at me like, how dare you say that? Nothing personal. I've known you for a long time, but it's really none of your business. So ask a follow-up question. Follow the court rules. I brought with me a prop, trying to make this as interesting as I possibly can. So here, I'm holding something in my hand. Michigan Rules of Court. We just got a new version, and I'm holding it in my hand. It's not expensive. You can buy it in the newsroom, or you can get it online for free. If you take it with you to court, I think you'll score points with the judge, frankly. And let me explain why. Going in counties all over the state, as electronic as we are anymore in the digital age, I find that judges almost invariably, every time a rule of evidence comes up or an argument about what a court rule actually means, the first thing the judge does is grabs the handy-dandy, tried-and-true rule book to look for the answer. Because many judges, at least my contemporaries, when we were in law school, this is what we used. We didn't use Westlaw online and all that fancy stuff that you kids are using. So the judge might be impressed if the judge sees you've got the rules book and maybe you've even read a rule or two and you know what the rules are. There is a rule that I want to call to your attention and discuss with you for just a couple of minutes, and that is Michigan Court Rule 8.115, and the subsection is C, subsection 2. Let me take a step back. We have sources of authority in the law: the Constitution, the statute, and as I'm finding out in a recent case, the common law. We have rules of operation for our courts all over Michigan, and it's the Michigan Rules of Court and the Michigan Rules of Evidence. Michigan Court Rule 8.115 talks about the decorum in the courtroom, what you should know when you're in there as a reporter. It's the same rule that we lawyers have to follow and the same rule that everyone has to follow. The judge may not let you have your cell phone in. I can tell you from a recent experience, the judge will yell at you if you're using your cell phone to record the proceedings and you haven't filed a request to record. Make sure you do that. The request to record is, I'm sure many of you are familiar with it. It is online at our awesome website, michigan.gov, and just go to the Judicial link and you'll find it. It is pretty easy to fill out. And there's something that is important that maybe you all should know, because I see a lot of intimidated camera people and news reporters. And again, healthy respect, yes, but don't be totally intimidated by the players. The court shall allow a request to record the proceedings upon request. Shall, that means the judge has to let you record the proceedings if you file the request properly in compliance with our rule. Now, the judge can take permission away if the judge finds that there was a disruption. There are a number of things that you should probably read and follow in the Administrative Order 1989-1. That's back when I was a radio reporter, and there was a lot of hue and cry about how disruptive it's going to be if we start allowing cameras in the courtrooms and electronic recording of our proceedings. This great fear about what was going to happen. It didn't really play out, at least not yet. Don't be the example. But there are some procedures and some things that you should keep in mind about rules of the road, as they say. Don't, for example, record an informant, a witness, jurors. I've seen that happen. The judge can, if the judge makes a finding that it's happened and been disruptive in violation of our administrative order, the judge can take your permission away. And I saw that happen about a month ago on a case up in northern Michigan. So I think that's mostly what I had by way of a formal presentation. This is what the request looks like. Again, super easy to download and fill out and submit to the judge. Just a couple of other additional tips. Often you'll find the judge's assistant knows as much, if not more, than the judge herself or himself. And it's a good idea to make contact with that person early on if you're going to cover a big case, get to know that person, and talk with him or her about the local procedures for that particular judge, the do's and don'ts, timeliness. Does the judge start early? Does the judge usually run 5 minutes behind the judge's docket that day? Is it going to be an especially busy docket that day? The little things that might help make a difference in you getting to maybe have a leg up and cover the case a little bit better and find that little interesting piece from otherwise very, very dry testimony and rulings that when you take your tape or your notes back to the newsroom, the editor says, man, don't you have anything that I can put on the front page, or don't you have anything that we can lead with tonight? I don't want to fill 1 minute and 30 seconds on the hearsay rule. Sometimes if you really get to know the big picture stuff, it becomes easier to find what could actually be a really interesting piece that's both accurate, informative, and helpful to your audience. So, John, do we have questions?
Any questions via social media? I don't know if we have any questions in the room here.
Yeah. What do you mean hearsay, John?
I know. Can you believe that? All that.
It's the rule against perpetuity.
My strategy on the bar exam was just hit C on the rule against perpetuities and move on.
Actually,
all that time and money we spent on studying the hearsay rule.
I do have one question actually now via social media. A reporter wants you to address a question about live tweeting during court proceedings. Let's say if there's a sequestered witness, for example, is live tweeting acceptable?
Is live tweeting acceptable from the courtroom?
Yes.
If it were me, I would step out if you need to do a post. Because if the judge sees you using your electronic device and thinks that you're doing something that might be improper, you don't want to stop the proceedings and be put in that position. So I would step out if you need to send something to the newsroom or broadcast it. That's just me. It tends to be less disruptive, and you never know if the judge is going to get cranked up about that, to put it colloquially.
Okay.
The other rule that I had forgotten was in our court rule on courtroom decorum is you're not supposed to capture conversation between the client and the attorney. That's off limits, which makes sense. The other day, I read in the paper a reporter had ascribed to the lawyer for an accused person who was in a very high-profile situation. It was actually a conversation between the accused, the client, and the lawyer. And I suppose if you're in the hallway and they overhear it and they're not careful about maintaining the confidentiality of the conversation, that's probably fair game. Certainly gave me a heads up and pause for thought.
Thank you very much, Mike.
No other questions? I think I actually filled 15 minutes though, so I did my job.
Now, our last speaker today is the Chief Justice of Michigan Supreme Court, Robert P. Young, Jr.
Well, good afternoon. You have heard from distinguished presenters and had an inside look at Michigan courts and the state's legal system. In past years, various communities have hosted the Law School for Journalists, but only those who were able to travel within a reasonable distance were able to participate. So this is our first attempt to employ the same live streaming technology that is used for oral arguments in this very courtroom when we have oral arguments, and in the courtrooms where we now have video conferencing abilities in almost every one of our courtrooms now. And our attempt is therefore to reach a broader audience than those who can physically be present here in Lansing. I would encourage you to review this annual report that details recent accomplishments of the judiciary, and there are printed copies of this available, but you'll find them also on the court's webpage at courts.mi.gov. So within the time remaining, and in a time when we are all concerned about how effectively our government is functioning at all levels, I want to tell you about the news from the third branch, and it's extraordinarily good. So in those few moments that remain, I'd like to highlight three of those strategic objectives that have been the focus of our reforms and for the past 5 years. And they include measuring performance to achieve outcomes, implementing technology, such as this, to increase access and efficiency, and re-engineering our courts to streamline operations and save money. First, every judge in this state now has performance measures, and court-by-court results are posted on each of the local courts' websites. Journalists should start looking at this data. You can look at the statewide data on the Supreme Court's website, again at courts.mi.gov/dashboard. Second, 2015 marked the third consecutive year of extremely positive reviews from court customers on annual trial court public satisfaction survey. We've surveyed 75,000 people in these 3 years, and those court users have said they were treated with dignity and respect, that service was timely, and their cases were treated fairly. Now that's not bad for an institution where roughly half the people who come in don't get what they want, so that more than 80% feeling that their case was handled fairly is kind of a testament to how effectively our trial courts are functioning. Third, Michigan has 164 drug, sobriety, and mental health and veterans treatment courts that reach 97% of the state's population. So offenders who participate in these problem-solving courts are intensively monitored, they receive needed treatment, and gain access to other assistance that they need to turn their lives around to become productive and law-abiding members of the community and avoid costly incarceration. We have data now that proves that people who complete these programs are far less likely, sometimes 2 or 3 times less likely to recommit crimes than those who do not participate. Fourth, implementation of video conferencing technology in more than 600 courtrooms statewide saved the Michigan Department of Corrections more than $3,000 last year. And that's far more, the local sheriff's department saved far more by allowing for virtual transports of prisoners in routine court hearings. Fifth, technology is one of the best means by which we can provide increased access to our justice system. That's why the Michigan Legal Help website and centers for those who cannot afford a lawyer are so important to us. And since its launch in 2012, nearly 1.4 million visitors have used the website, accessing more than 6.5 million pages and getting help with issues that range from landlord-tenant disputes to personal protection orders, all without the need of a lawyer, thereby reducing costs, protecting litigants, and improving outcomes for families. Sixth, virtually every court in Michigan now offers the convenience of paying tickets online. And that's really old news. What's new are the 7 courts that are offering online ticket resolution programs that allow eligible drivers the opportunity to resolve their ticket without going to court, saving time away from work and family, as well as potentially reducing or eliminating points related to the violation. The police officer who wrote the ticket can stay on the street and avoid a court appearance. And finally, or seventh, right sizing of the judiciary to match the workload. I want to stop there for a minute. I want to ask you what other branch or division of government has ever voluntarily reduced its size. That's what we're doing in the judiciary. Our reduction of 26 judgeships so far of the 40 that we asked the legislature to authorize in judgeships is already saving the taxpayers $10 million since 2011, and that's a net reduction of 6 more seats as recommended in last year. So finally, my colleagues and I are extremely proud of what our judiciary has accomplished in the last 5 years. Our judiciary is leaner, our courts are more customer-focused, and the administration is more efficient and timely and transparent. All of you journalists have far more resources available to you to examine how well we're functioning. And our goal is for Michigan's judiciary to be the national model of efficiency and service to the public. And we will march toward that goal by continuing to measure our performance, to implement technology, and re-engineer our courts. And we will continue to convey information about those goals to the media, as well as our citizens. So thank you again for joining us in this program. We hope it's been educational. And please join us again on April 6th and 7th, which right here in this courtroom for our April oral arguments, or you can watch on the live stream from your office. Thank you so very much for participating. I think we're concluded, are we not?
Yes, we are.
Thank you.